Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting in diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. My name is Judge Henry, and I am your panel chief today. I'm joined by Justices Sachs and Englander, and delighted to have them with us. It is November 13th, 2020. Welcome to the Appeals Court. This is our first case on. We are on Zoom, but we are otherwise as if we are in the courtroom. So each side has 15 minutes with no rebuttal. I assure you we've read your material, so the time is yours to use as you wish, but I'd encourage you to get to the heart of the matter. The first case we have on today is matter number 2020-P-0687, Commonwealth versus TERRENCE JACINTHO. Attorney Dahlberg, please proceed.
Thank you. Good morning, Your Honors. Nancy Dahlberg on behalf of TERRENCE JACINTHO. And I will take you at your word, Justice Henry and Justices, and I will try to go through the outline of the deficiencies at the hearing at which Mr. Jacintho's probation was revoked, and he was sentenced to 2.5 years for a first offense OUI. There were serious deficiencies at this hearing, as are revealed in the rather brief transcript of the hearing. And they really require that the revocation and sentence be vacated. There are two separate categories of rights that were not provided to Mr. Jacintho. The first of these have to do with the right to counsel at the hearing, of which there was no valid waiver. There's no dispute that he was entitled to counsel at the probation revocation hearing, and it was structural error when he was not provided with a colloquy to determine that any waiver was voluntary and intelligently made.
What, is there any case that says a full colloquy was required?
There are a number of cases, Your Honor, that require that a judge determine that that a colloquy be given so that the determination can be made that a waiver is voluntary.
Well, in the probation context, I guess I should be more specific. Is there a case saying a full colloquy is required versus merely the judge assuring himself or herself that the defendant has some understanding of the rights being given up and what the defendant is taking on by representing him or herself?
I have to honestly say that I would have to review the cases that are cited in the brief. The rules of probation violation hearing in the district court make it very clear that a judge has to determine after a colloquy that it be voluntarily, knowingly and intelligently made. The form itself, which the judge signed at page 16 of the record appendix, states that it was after a colloquy, an oral colloquy. And of course, the cases on this are very specific. A probationer or defendant has to be made aware of the perils of self-representation, and questions have to be designed to elicit that he understands the implications of going unrepresented.
When you say the cases are very specific, I read the cases to not be very specific. I read the cases to be explicitly non-specific. Commonwealth against Moran, which talks about, I think, a decision by Judge Coffin from the First Circuit, says there's no specific form that a colloquy needs to take. Isn't that our law?
That's fair enough, Your Honor. The specific questions are not, I should say, the questions are not specified. The questions have to determine that a probationer or defendant in a criminal case is aware of the implications of going unrepresented. This isn't a hard choice here because there was nothing. Are you going to?
Counsel, I certainly understand your position, but there wasn't nothing. I mean, he asked him, he says, I don't want a lawyer, right?
He said, do you want a lawyer? And this was after one lawyer.
He says, I don't want a lawyer. He says, you sure? He says, yes. And he's got a signed document that says that he waives his right to counsel.
Right.
Right?
And code, yes, and the cases have made it clear that the signing of a form without a colloquy is not dispositive in any way.
Okay,
In
what
this
case do you want to send me to find that principle?
Coat says that Commonwealth versus Coat, which is cited in my brief, says that the signing of a waiver form is not dispositive because it happens as it did here. Okay, he's given a waiver, but there was no explanation about the perils of self-representation. And this is, Your Honor, in the context of the first bar advocate appointed to him, swearing at him in the lockup, the second one standing up and saying that he had a conflict, a legal conflict, and the third one, who was going to get the case, apparently saying he's declined counsel. There was no suggestion that there was another lawyer to represent him. So that would not be dispositive. And in fact, the Commonwealth included the Judge Edmonds, who's a colleague of Judge McGovern's in the court, when she denied the motion for stay, which this is not being appealed here, but the Commonwealth did include it. And she makes the point, although the defendant signed a waiver of counsel, he was not given a colloquy to establish whether the waiver was knowingly and voluntarily made. That is the law, Your Honor. And there's nothing here to support any kind of colloquy.
Could we say that there was an implicit determination that the rule that you cited earlier, the district and BMC rule, says a waiver shall be accepted only if the court determines that such waiver is being made knowingly and voluntarily. Now, as you said, there's no express determination. Is there a basis for us to say that there was an implicit determination?
No, this has to be very clearly made, these cases, excuse me, and I'm just looking for even where the form says that I further certify that after an oral colloquy with the party, there was no oral colloquy.
Well, I
There just was
guess
no
the issue is the judge, I mean, there was some, albeit minimal, colloquy because the defendant made a statement and the judge asked him if he was sure. What what do you think the judge should have asked him? Like, what specific thing do you think would have perhaps changed the outcome here?
The judge was required to explain to Mr. Jacinto what the risks were, what the procedure was, what he was facing,
Right,
what
but
the
what's
perils.
the risk? I mean, he came in and he so first of all, he is an experienced customer of our criminal system, right? He had quite a record, and he came in and he said probation says I'm getting 2.5. So he knew that.
I'm excuse me, Your Honor. Sorry.
No, that's
What Mr. Jacinto was saying, well, we can speculate because he wasn't represented by counsel, but the clear implication to me of his statement was that he was being told by someone that he was facing, that they wanted some 2.5 years of 2.5 on and after, and he was objecting. There is no basis for the Commonwealth's wild speculation that he was saying, oh, fine. I don't want a lawyer. I don't want to do anything because this is fine with me. That is wild.
I'm not saying that it was fine with him, but when you say he didn't know what he was facing, he knew he was facing 2.5.
He didn't know the perils of self-representation. The prior probation had been extended twice. So that wasn't a hearing. He doesn't know that he has a right to be heard under oath, that he has a right to argue against violation, finding a violation and disposition, that he has the right to see exhibits and present his own evidence, that it would be, was he truly not wanting to, get his minimum 7 days so he could prepare for this? This is a heavy sentence. This is a first offense OUI. And he received none of the rights, which I'm getting into the second part of this, that he's entitled to. And these were also findings that Judge Edmonds made when she said that there was a very reasonable chance of success on this appeal. But because of these prior defaults and because of the COVID situation in Falmouth not being in Barnstable not being a problem, that was the case. But there's no explanation of the reasons. He doesn't even check, the judge doesn't even check off a box that says there's a finding of a preponderance of the evidence.
Okay, so counsel, the judge describes the photos that he saw, but you argue that, that he was purportedly given some such documents. We know from the transcript that the judge was given photographs and a police report from the crime that was being alleged to be the violation, right?
We know he was given something that was described as a police report and photographs. They were not made exhibits. They were never included in this record. The Commonwealth appended them and created a document. Whether or not
that they weren't somehow left with the court, is that the issue?
they weren't made exhibits as they should have been in a probation hearing, or the Commonwealth could have moved to expand them. But whether or not they were included doesn't affect the fact that Mr. JACINTHO didn't receive any of the rights to have a fair hearing about them. And so I don't know exactly
Can I ask you,
Commonwealth.
is there anything in the record that indicates that the police report, let's assume it was given to the judge, was also given to the defendant?
I think the Commonwealth concedes that it wasn't. He wasn't given anything from the record. The record indicates he wasn't given anything. He wasn't, and it appears that he was.
I didn't see the Commonwealth concede that. That's why my question is asked, what does the record show? And then my next question was going to be, who has the obligation in this appeal to try to clarify that for us, if anyone?
I would say the record shows that he was not given anything. That shows that the probation department handed some items to the judge, which apparently he took with him and read in private. That was another finding of Judge Edmonds on the motion to stay. He apparently took them into a recess, came back out and said, I've reviewed what I have, and here's a sentence. There was no opportunity for Mr. JACINTHO to respond, to argue for a different disposition, to, provide his own testimony or.
Aren't these proceedings usually two-stage, where the first stage is, did he violate? And the second stage is, what's the consequence? And then the defendant or his counsel and probation would be heard on that?
Not necessarily, Your Honor, to my understanding. Sometimes there's a preliminary hearing if somebody's being held in custody on the particular matter. In this, one issue here is that under the rules, he would have been entitled, once served with this notice, to a period of between 7 days and 30 days to prepare. There's a piece of paper in the probation file that says that he waived the 7 days. Another finding of Judge Edmonds, and an argument that we make, is that under the rules, it should have been determined that he in fact understood the implications of signing that. I think sometimes probationers may be encouraged to sign that because they're told, the probation is going to be extended, nothing's going to happen. I don't know. But it's one line, excuse me.
Yeah, what my question was referring to was Rule 6D of the probation rules, which says if the court finds that the probationer has violated one or more conditions of probation, the probation officer shall recommend a disposition, and the probationer shall be permitted to present argument and evidence relevant to disposition and to propose a disposition. I didn't see that happening.
It didn't happen. He was not given any opportunity to do anything. So I agree with you. He was not given opportunity to argue. It is unclear. I agree about his presence, but I think it's fair inference that Mr. JACINTHO was not present after the sentence was announced. And although the Commonwealth, the Commonwealth takes the defendant to task for not going back to Judge McGovern, who I understand for some months has not been sitting on criminal cases. That's what I was told. But in any case, the fact that the hearing did not end when the announcement of the sentence was made, and it goes on for quite some time. So the Commonwealth's assertion that it doesn't matter, I would take issue with.
So the Commonwealth argues you're wrong about whether the defendant is entitled to 7 days notice of the probation violation hearing. What do you say to that?
I think that the Commonwealth is confused there between his right to that notice and the right to a preliminary hearing. It's the issue whether someone's in custody. However, the rule itself does not explicitly state that a waiver of that rule. He did sign a piece of paper. There's one line, and it's in the record appendix that says, I waive the right, you know, I'll agree to an immediate hearing rather than the 7 to 30 days. But, you know, an argument here, and that event was absolutely in keeping with the rest of what I think charitably is called a hearing here. But the Judge Edmonds agreed, and I would argue that there should be some determination that the probationer understands what he's giving up by signing this one line that says, I agree to an immediate hearing.
Thank you very much, counsel. I think we
Thank you.
understand. Ms. Palumbo. We can't hear you, Ms. Palumbo. Unmute yourself.
Still muted.
You need to unmute.
We may need our clerk.
There you go.
Okay, thank you. Good morning. May it please the court, Karen Palumbo for the Commonwealth. First and foremost, the defendant is incorrect. The Supreme Judicial Court has not mandated a particular colloquy or particular words for waiver of counsel to be
But it
voluntary.
does have to be a determination that the waiver was knowing and voluntary, correct?
The waiver must be knowing and voluntary, but the court focuses on the subjective awareness of the decision and its consequences. And
So
it
how
takes,
do we know that this waiver was knowing and voluntary?
first, again, the defendant affirmatively stated on the record that he did not want an attorney, and the court is entitled to look at the defendant's knowledge and understanding, and it can be gleaned from all the circumstances, including the defendant's experience in the criminal justice system. The defendant has a lengthy criminal record, and he has
You said
many.
the defendant has a lengthy criminal record. I do not recall seeing that in the record before us.
It is impounded. I provided the defendant's query for the court. It's
And
in
we
my-
conclude from that, Carrie, that the court activity record information, we don't know anything about his representation in those prior cases. I mean, he could have been dozing off at the table while counsel was representing him and have no appreciation of what is involved. And we don't know if he ever went through a hearing subject to these probation violation rules where he knew what his rights were, do we?
We don't know specifically. He does have 6 prior violation of probations on his record, 5 of which resulted in incarceration. But no, we do not know the details of those. But I would suggest his experience with the court, having gone through a violation of probation, the defendant was aware of the consequences. Not only was he aware.
So this argument takes me by surprise because I don't recall really reading it in the briefs. And the argument amounts to saying that even though the judge didn't know about this lengthy criminal history when the judge decided that he could go forward without a lawyer, we can, on appeal, conclude that it was okay for the judge to reach that determination because on appeal, you've told us that in fact he has a lengthy criminal record?
First off, the judge did review the CARI, and he states that on, I believe.
How do we know the judge reviewed the CARI and where was the CARI in the record? I'm so confused. I apologize.
The judge stated on the record that he reviewed the defendant's CARI. I believe it's transcript at page 11. And also it's in the Commonwealth Supplemental Appendix number 2, which is impounded. But in any event, the defendant affirmatively stated that the defendant was well aware of the 2.5 years that he was facing as a result of the probation violation.
How can the defendant be aware he was facing 2.5 years when probation was recommending 2?
He met with probation prior to the hearing, signed the paperwork, and he told the court that he was facing 2.5 years, or they want to give him 2.5 years. So clearly he knew.
That's not what he said. He said, and now they tell me.
Yes.
But,
No,
but
we
he,
don't know who
but
told
who's
him.
they? Because that doesn't make any sense, counsel. Because probation stood up and suggested 2 years. So the notion that he knew 2.5 based on that statement really literally doesn't make sense.
Well, he had met with counsel prior, before he fired him. He may have told him 2.5 years. That was the maximum
He may have
sentence
told
for
it.
the underlying OUI. So that is the penalty that he was facing. And he states that he's aware of it. So I would suggest that he voluntarily waived his right to his attorney. Based on his history, his affirmative representation, his familiarity with the violation of probation, and his awareness of the penalty, I would suggest that it's voluntary. And yes,
So-
would it be better?
Can you
If-
show me, counsel, where in the transcript the defendant was given an opportunity to be heard?
The defendant spoke with the judge. He told he told the judge that he wasn't held on dangerousness and that he did not do that, that the victim fell down the stairs. He didn't have other opportunity other than that, but he was aware of the basis of the revocation, and he just told the court that he did not commit the crime. He had an opportunity in that regard.
So he had if I recall the transcript correctly, he interjected.
He did, yes, Your Honor.
Right. And that was the only way that he was given any kind of opportunity to substantively respond to the revocation, right?
Yes, and that's the only way he did
Do you
respond
think
to it.
that that is the way that we should be conducting our probation revocation hearings?
Well, the defendant was acting as counsel for himself, and he should have.
Do you think in a revocation hearing that the judge or anybody in the courtroom should actually say the defendant now has an opportunity to respond? Or do you think it's okay that we just leave it, that the person has to start yelling out, interrupting other people?
It would have been better had the court said, now you may speak, but in this case he didn't, and I would still suggest, even that the defendant was not given that opportunity. He was present at the hearing, he participated in the hearing, and he was well aware of the basis of the revocation. He knew the facts of the case, and he voluntarily waived his rights.
You say that he knew the facts of the case. I take it, well, so first of all, do you agree there's no indication in the record that he was handed the photographs that the judge saw or the police report?
Well, there is, in the notice of probation violation and hearing form, it says that which the defendant signed, it says that the complaint was attached. But in addition to that, the defendant was arrested.
What was attached?
It says the complaint attached.
Right, and what was,
Complaint in the new case? That's the complaint in the new case.
The basis of the probation revocation violation.
Right, but the complaint in the new case wouldn't attach the police report and the photos, would it?
No, but in addition to that, the defendant was arrested on this offense, he was arraigned on this offense, and he was held on bail on this offense. The defendant knew he was coming back to the court for a probation revocation hearing, but the probation department provided him with notice, which he was handed that day and which he signed, that the basis of the revocation was assault and battery, serious bodily injury, assault and battery, family member, etc. So the defendant was well aware of the facts of the case and well aware of the basis of the revocation.
Well, you may be right, counsel. Maybe he was. But there's nothing in this record that tells us that. Is there?
I disagree. I believe the defendant had actual knowledge based on the history of the case. He was arrested, arraigned, and detained.
And that
he knew.
the fact that he was arraigned and the fact that he was detained, we can, I need you to take me through this because I have like a 16, 17 page transcript, which is the only thing that really tells me what happened in this hearing. So you say I should be able to infer from the fact that he was arrested, arraigned, and detained, that he knew what the charges were for which he was coming forward in the probation revocation hearing.
Well, he knew what charge he was arrested and arraigned for and detained. When he came forward for the probation revocation hearing, he was handed a form by probation, which indicated that it was a new criminal complaint.
And how do we know that?
I'm sorry, what?
How do we know that?
The defendant signed the form. It's the notice of probation violation and hearing. And also, the defendant stated on the record that she fell. She was drunk and she fell.
So we can infer from his, as Justice Henry points out, his interjection in the middle of a discussion of whether there's been a 58A, that he knew exactly what the charges were against him because he said, I didn't do that, she fell.
She fell, she was drunk, which is what the victim was punched repeatedly and fell down the stairs. That was the defendant's response to that. And also the fact that he knew,
I'm sorry, counsel. The fact that the victim was punched repeatedly is not in the record. It's not there. We have nothing that tells us that he knew that was the allegation against him.
He knew the incident that occurred, and he knew he was under arrest for it. The judge later in the transcript on page 10.
Are you telling me it's the regular practice of prosecutors from which we can take judicial notice that he was advised of the exact details of the police report at some point?
No, I'm not suggesting that, Your Honor.
That wouldn't be my understanding.
It's not
If he had
mine.
the lawyer had access to the police report, then maybe the police report had been shown to him in the past. That's all that I think I can infer at this point, right?
Well, the defendant was arraigned on the charges.
Yeah, but that's just a statement of charges, right? Does the police report have to be provided at that time?
Yes, usually the the prosecutor reads but I can't say what happened at the arraignment, but usually the prosecutor reads the police report, reads the charges to the court. But I can't say that did or didn't happen at that point.
The police report, or he reads the charges?
He reads the facts of the case.
We don't, the point is we don't know because we don't have a transcript of that arraignment, right?
Correct. But
So the defendant has in fact moved to strike, and I wanted to understand the Commonwealth's position on that.
first, he moved to strike the police report, which is the basis of the probation revocation hearing, as well as the photographs. That judge relied on both of those in making his decision on the probation revocation, so therefore they are properly before this court.
Well, but okay. We have what's definitely properly before the court is what the judge described in the transcript, but this seems like a place where perhaps the Commonwealth should have moved to reconstruct the record before they just handed stuff, because we have no idea. We don't make any findings of fact. So I have no idea if the police report you're handing us in your appendix is the police report that the judge had.
First and foremost, I'm an officer of the court, and so I am simply presenting the court with the police report as it was. But also, the standard rules of evidence do not apply to a probation revocation hearing. The defendant contends that it wasn't admitted into evidence, and it wasn't marked for identification either, but the standard rules do not apply to a probation revocation hearing.
Things still have to be admitted. The rules regarding what can be admitted may be inapplicable so long as the evidence is reliable, but the rule that something has to be admitted to be considered, I'm not aware, is not applicable to probation proceedings.
I would go back one other rule, which is if I am presenting for the Commonwealth in front of a judge, the very first thing I do is I hand to the opposing party what it is I'm about to hand to the judge. That's something I think I learned when I was very young. Maybe the first time I ever got in a courtroom. And there is no evidence that that occurred here. So we don't know that the defendant even saw what was handed to the judge. Am I wrong about this?
No, we don't know that it was handed to the judge, but the prosecutor was not involved in this. This was a probation revocation hearing, and it was the probation officer.
The Commonwealth with the defendant's liberty at stake. I don't understand why the rules don't apply. The defendant got 2.5 years. The person representing the Commonwealth was handing materials to the judge. It seems to me they also ought go to the defendant, no?
Well, they weren't handed to the defendant in this case.
How do we know that? Counsel, how do we know?
Well, we don't know whether they were or they weren't handed to the defendant. And the defendant didn't file an affidavit stating that they weren't. We didn't follow up and file an affidavit that they were. However, the 2.5 years is a reasonable sentence in this case. The
That
defendant,
I understand. Okay.
Counsel, may I ask a question? Just stepping back from the facts of this case, and we're asking you obviously a lot of tough questions. We understand you weren't counsel at the hearing. Is putting the facts of this case aside, is there a process if a district attorney's office looks at the record of a probation violation hearing where it's been appealed and says, you know, this is just too sloppy. This will not stand up. This is not right. Is there a process for a district attorney's office to go back and essentially have a do-over or remedy those portions of the hearing that weren't done right? And, you know, then if probation gets revoked or whatever happens as a result of that hearing, that can be appealed.
I suppose there is, yes, but that wasn't done in this case. And so if this court determines that, the case can go back and have
Right.
probation.
But what I'm asking is, can a district attorney's office make that judgment on its own before it comes to us in this posture?
Yes, they can, Your Honor.
And how would they do that?
I'm not sure, Your Honor. I will have to check.
All right, well,
I should
it might
echo
be
what
worth,
Judge
it
Sachs
might be
said,
worth
counsel.
looking into how that is done.
Okay,
I should
thank
echo
you.
what Judge Sachs said. We are asking tough questions, and we know that you weren't the person standing in the courtroom. But you understand why we're asking the tough questions, I'm sure.
Of course. But I would just suggest that in the circumstances of this defendant, that he voluntarily waived, he was aware of the underlying basis of the revocation, and ask this court to affirm the revocation of probation. Thank you.
Thank you.
And we are live and on the record.
This is a continuation of the November 13, 2020 sitting of the Appeals Court. The next case is 2019-P-1775 Commonwealth versus Sheehan. Attorney Hirsch, please make your argument. Each side has 15 minutes, no rebuttal.
Thank you, Your Honor. If it please the court, David Hirsch, representing Mr. Sheehan. Your Honor, the motions judge in this case made two decisions. One, that the statements of Ms. Lori Kendall admitting to being the driver at the time of the incident were admissible. We agree with that. Two, that those statements would not likely have changed the results of the trial. We disagree both with the standard employed by the judge on that and with his ultimate conclusion on it. I think the two most applicable cases here are Nut Brown and Alcide, both of which we have cited I've cited in the two briefs.
Nut Brown goes to whether it was admissible, not to the prejudice prong. Is that right?
No. Nut Brown also finds that there was ineffective assistance of counsel because it was not admitted, which requires a finding that it might have changed the results of the trial, as does Alcide. In both of those cases.
Counsel, I want to make sure we all are on the same page factually for a minute. Do you agree that the third-party witness, the other motorist, Mr. Brophy, testified that he saw the Jeep roll over and then he saw a man exit the driver's door after the Jeep came to a rest?
Yes, I do, Your Honor, but I don't think that's conclusive in any way, particularly in a case that in a car that rolled over at least once, or at least once one person seemed to have been unsecured in the car. So we really don't know how people ended up where they did. It is evidence, Your Honor, but the key is not whether there was evidence against Mr. Sheehan. Of course there was. The key is whether there might have been a change in the verdict had the jury heard Ms. Kendall's admittance to the crime.
Once the judge decided that it was ineffective not to offer this evidence because it would have been admitted, the judge then said, well, it wouldn't have made a difference. Was the judge essentially deciding that the jury would not have believed the statements that Ms. Kimball made in the medical records?
I don't think the judge said that, Your Honor.
Well,
I think the judge merely said that I think the most important statement the judge made was, well, if the jury didn't believe Mr. Pinn and Mr. Reynolds, the two friends who had said that Ms. Kendall had confessed to them, then they wouldn't have believed Ms. Kendall herself. I don't think that is a reasonable finding, Your Honor, particularly given that in Nut Brown, the court said, because the defendant had a right to present evidence that another person committed the crime, the issue is one of constitutional dimension, and our review looks to whether any error was harmless beyond a reasonable doubt. It cannot possibly reasonably be said that
That's confusing, because I understand what we're doing is we're reviewing a decision with respect to ineffective assistance. And so the standard that I thought was applicable is whether there's serious doubt as to whether the verdict would have been the same. Now you're saying harmless beyond a reasonable doubt. Help me rationalize what standard is you think we should be applying.
I think, Your Honor, here we have the confluence of two different standards that we have to kind of look at them both. Yes, of course, for ineffective assistance, the regular standard is a substantial risk. But here, in Nut Brown, we have the court saying that failure to present, that not presenting the evidence that another person had committed the crime must be shown to be harmless beyond a reasonable doubt. I think we have to look at, it's a very good question. I think we have to look at the second of those two standards, the reasonable doubt standard, harmless beyond a reasonable doubt standard, in interpreting whether there was a miscarriage of justice, a substantial risk of a miscarriage of justice in this case.
The claim that you've presented, the argument you've presented is an argument of constitutional dimension, which is that there was ineffective assistance of counsel. But we have a standard that we apply in determining whether there was ineffective assistance of counsel, or that the lower court judge applies, right? And it has to be manifestly unreasonable conduct, and then prejudice prong is serious doubt as to whether the verdict would have been the same. Then we get that on review. I don't think there's room for harmless beyond a reasonable doubt. I think we're reviewing the decisions of the lower court on a new trial motion, and it may simply be abuse of discretion or other error of law.
Well, Your Honor, first of all, I think Nut Brown is fairly clear on the issue. I agree with Your Honor that there is a conflict within the case law on the subject. But secondly, let's assume that only substantial risk is the standard here. We still—
I'm not ignoring you. I'm going to pull down Nut Brown. You keep talking.
Very well, Your Honor. This still, Your Honor, even if the standard is substantial risk, there is certainly a substantial risk here. My sister has done an excellent job of showing why a jury would not have been likely to believe Mr. Pinn or Mr. Reynolds. That doesn't mean they weren't telling the truth. It just means a jury was unlikely to believe them. Combined with Ms. Kendall's testimony, that would have been exceptionally strong evidence of Mr. Sheehan's innocence, and certainly creates a substantial risk of a miscarriage of justice.
I go back to my initial question. When the judge says, well, if they didn't believe Reynolds and Pinn, they wouldn't have believed the Kimball statements in her medical records. Is the judge essentially making a credibility determination about her statements in her medical records that really was for the jury to make?
No, Your Honor. The motions judge made no ruling on her credibility other than saying, well, after all, she had been in an accident. There was also the claim raised that, and I may be forgetting details of Not Proud here, Your Honor. Excuse me, of the lower court's ruling here, Your Honor. But there was the claim made that she might be, since 2 weeks later, Mr. Sheehan allegedly told her, you take the fall because you'll get in less trouble. There is absolutely no reason to believe that Mr. Sheehan and Ms. Kendall communicated in any way between the accident and the time that Ms. Kendall made her inculpatory statements about herself. None whatever. And since, Your Honor, we're not talking about the trial judge here, but rather a separate motions judge, this court looks at credibility issues like that de novo.
The reason I'm sorry, go ahead.
If you're finishing the line of thought, go ahead.
Yeah, the reason I ask about whether he was making a credibility judgment is because of cases like Roberio, the SJC's 1998 decision, which says that in a new trial motion based on ineffective assistance, once the judge has determined the performance prong was deficient, then if it's a question of not having presented a witness to the jury, the judge should not evaluate credibility. That's the jury's role. So that's why I'm wondering whether, in saying if the jury didn't believe Reynolds and Pinn, they wouldn't have believed Kimball's statements in the medical records, whether the judge was making an impermissible judgment about the credibility of her statements in the medical records. And when he says, well, the jury could infer that if he came to her 2 weeks later and asked her to lie about it, he maybe made the same request to her as the car was rolling to a stop, then, he's making a judgment about how credible her statements would have seemed to the jury and whether that's permissible.
My two-word response, I agree. Your Honor is right. And under Roberio, he did not have the discretion to make the decision about what the jury would have believed, whether the jury would have believed Ms. Kendall, excuse me.
Well, but then what does that do to the standard that we're applying, which is whether there's serious doubt as to whether the verdict would have been the same? I mean, you're telling me that statement then has to be accepted as true, even if in the context of all the other evidence, the judge can reach the conclusion that it wouldn't have the same kind of weight?
Not at all.
There's other evidence in the case?
No, Your Honor, I'm certainly not saying that the judge has to accept these statements as true. I'm merely saying, as Judge Sachs just pointed out, that it is not for the judge to say what the jury would or would not have believed, that it had to have been left up to the jury. And therefore, under Roberio,
to be able to say, okay, the evidence that you're proposing, Attorney Hirsch, would have been that she was the driver. However, the rest of the evidence the jury heard included the fact that all the blood was on the passenger side of the car, and that someone else came out of the driver's side of the car immediately after the accident. And therefore, I may not credit what she said, or the jury may not have credited what she said. Can't the judge do that?
The judge can say that there is no likelihood that a jury would have changed its mind on the basis of this evidence, depending on which standard we're applying here. The judge cannot, under Roberio and several subsequent cases, say that, well, she's not believable.
Which
That's
cases are
different.
those? Do you know which cases those?
If the court will give me several hours after the hearing, I can shepherdize Roberio. I don't have them at hand.
If you're going to send something in, could you please clean up or clear up one question I had about the record. Your brief refers to the defendant being charged with ABDW, serious bodily injury. But as I looked at the complaint, I didn't see the serious bodily injury component. And as I looked at the judge's charge, not the complaint, the docket sheet, I didn't see the SBI portion, and the judge's charge didn't mention it. We don't have the indictments in the record. So it's my understanding from the record that he was not charged with SBI, the portion of ABDW. He was charged with OUI, ABDW, SBI, but not ABDW, SBI.
It wouldn't be the first time I made a mistake like that. I will check, Your Honor.
Thank you.
So I have a couple of questions. First, does the record indicate the weather and the road conditions? Because there's an issue about, it goes back and forth between whether the accident was at 4 o'clock and 7 o'clock. Is there an indication on that?
About the road conditions or about the time?
Both. I mean, we have a rollover here without a lot of explanation about that. And you're challenging whether or not there was evidence of impairment. So if the road conditions were good and the weather was good and there's a rollover, then that could certainly be an indication of impairment.
Your Honor, whether it's some piece of evidence, I would not disagree with you. Whether it's sufficient evidence, I would. Here we have no knowledge of what was going on in that car, both internally in terms of how the car worked or what was going on between these two people here. If, say, somebody interfered with somebody else, if the passenger interfered,
I understand.
if something went wrong with the car.
Counsel, I understand, and time is running short. So my other question is, should the motion judge consider whether Ms. Kimball's statements that she was the driver when she made them to the medical people, should the judge engage in any kind of voluntariness analysis where she possibly also had consumed illegal narcotics, and certainly she was had severely injured, had head injuries and had fingers amputated?
No, Your Honor, because voluntariness does not go towards the statement of a non-suspect. It's a non-issue. Certainly, in terms of believability, that's something a jury could consider, whether she was capable of making a coherent statement at the time. I would point out that the medical records show alertness and ability to give a good history on her part, but a witness has no right to be limited to voluntary statements.
You say the medical records show alertness and ability to give a good history. As I read the medical records, it's not clear to me that we actually have the same statement made twice, once to the EMTs and once to Lawrence Hospital. It looks more to me like she made the statement to the EMTs, who then repeated it to the hospital, who then put it in the record. What do you say to that?
I say that it's very unclear from the record. The way I interpreted it, there were at least 2 statements she made, one to the EMTs and one to the hospital personnel. Beyond that, I can provide no other interpretation.
All right, counsel, thank you. I think we understand your argument. Ms. Semmel?
Thank you, Your Honor.
May it please the court, if I could start backwards with Justice Englander's question about whether there was one statement or 2. I don't think it's particularly clear. In my mind, in fairness, I think there may have been 2, but it's not clear. Clearly, she made one to the EMT because it's in the EMT records. And the passage I quoted in my brief is that the nurse's notes reflect patient's speech is slow and slurred and states that she was driving the vehicle and was restrained. From that, the way it was phrased, I thought that she had perhaps made the statement to the nurse. It's not 100% clear. Certainly, the other statements that are recorded were repeats, I think. So she made it either.
Aren't those statements admit? Somebody has.
Okay, anyone who's live streaming, please stop that because it creates a feedback loop. Okay, you just have to watch on the Zoom. You can watch the live stream later, please. Okay, Attorney Semmel, we'll give you extra time if you need it. Please continue.
Thank you. I think there was a question.
There was, and now I've forgotten what it was. So keep talking and I'm sure I'll remember it in 2 seconds.
All right. I think as to the judge's determination as to prejudice,
Oh, I know what the question was. I'm sorry. Wasn't the statement in the medical records admissible under Section 79 as a statement related to her treatment?
I think that it was not. And the reason why is I don't think there's any explanation that has ever been made as to how the fact that she was in the driver's seat impacted her injuries, her condition, her symptoms, her treatment. I think that the analogy that the defense provides, that somebody was coming at a victim with a knife when the victim then had lacerations, shows a direct connect between these circumstances and the victim's medical treatment.
Let me say, since I'm not sure where the feedback is coming from, but since the statement kept getting repeated in the medical records, whether it was from her or from prior medical records, it seemed like it was important enough to those medical personnel to include. And the reason it might be important is because if she says she started off in the driver's seat and she ended up in the passenger floor well, is that some indication of the amount of trauma or the type of trauma she might have suffered while the Jeep was rolling over, and therefore whether what kind of looking the medical personnel need to do for injuries that might not be immediately apparent?
If there is some basis for that, some medical basis for that, it's never been introduced or posited by the defense. I don't think it's obvious.
I mean, it's in the medical records, right? And I mean,
we do.
How do we decide that it's for the purposes of medical treatment? What Justice Sachs just posed is I think a terrific question. I had in my mind the question of whether if she is the driver, they start to look for injuries to the chest because she might have struck the steering wheel. It's the same kind of question. Isn't it relevant to the people treating her? And you suggest that the defendant has to put that forward, but it seems to me that the question coming from the way the statute reads is really more a question for a medical provider. Is it relevant enough to put in the medical records?
Well, I do think 2 points. One is that we see all the time information that's included in the medical records that is redacted, that is excised before it goes to trial for various reasons, including because it's not directly relevant to the medical treatment. I think the case that I cited in my brief had to do with the fact that the victim was sitting in a taxi cab when he got shot. I understand that's not exactly the same thing, but it's clear as a starting point that not every fact concerning the incident that got the person to the hospital is relevant, is for medical treatment.
Or is for purposes of medical treatment?
Yes, and so I do think it's the defendant's burden to or would have been had they moved to admit the evidence, and now it's their burden to show ineffective assistance to provide some authority for the idea that it was actually medically relevant.
So I'm sorry, feedback is coming from. If you can't understand me, let me know. The putting aside the medical records issue, the judge decided that it would have been admissible on 2 other grounds, and therefore it was a substandard performance for counsel to not have offered it. Where you have a trial judge saying that, I understand he wasn't the judge at this particular trial, but where you have a judge who reaches the conclusion that this evidence would have been admissible, then unless that is such a manifestly unreasonable conclusion that no other judge could have reached it, doesn't that mean that there was a reasonable possibility that this evidence would have reached the jury? And then we have to decide whether that would have made a difference.
Well, I do think that the judge made some mistakes in his findings. One was, entirely our fault. when in the statement against penal interest, I think that we conceded in our motion that the victim would be viewed as unavailable due to her lack of memory, and that was just wrong. And the defense makes a point that we should be held to our waiver, which of course this court can do. But I would suggest that you not do that simply because, one, it was just objectively wrong.
The defense also makes the point that even if that Hedberg case had not been decided at the time, or even though it hadn't been, there's a question of a constitutional right to present a defense, which was well established at the time.
Well, except that this is an ineffective assistance claim, and we're reviewing it with regard to the reasonableness of trial counsel at the time.
Sorry, I
2014.
misspoke. I should have said a constitutional right to have reliable hearsay admitted, even if it doesn't fit strictly within a hearsay exception, if it's essential to the defense. That's a paraphrase of the cases, obviously, but I think you understand what I'm referring to.
I do, and I won't repeat myself. I think you understand my point.
Maybe
but I
you
think
can go to prejudice.
if I could, I will definitely go to prejudice. If I might just briefly say, I think that the problem with Judge Lang's rulings was that I don't think he took into account sufficiently that whether or not the statements were sufficiently probative or reliable, and the defendant has no right to put in unreliable hearsay. And that has to do with
Statement.
So to go to
It
the
had so
question that
many
I asked him, asked your Mr. Hirsch, should the judge consider whether the statements from Ms. Kimball were voluntary?
I don't think strictly voluntary, no, but I think that that it's somewhat similar. It's a similar analysis when we consider whether or not they were reliable and probative, and the same factors play into one as the other. And in those, I won't give you the laundry list of the victims, extreme trauma, the amputation of her fingers, and all of the medical evidence as to her state at that time.
To determine whether the statements were reliable and probative, what standard would the trial judge use?
I think that's, oh gosh, I think that's a standard. Whether they were sufficiently probative, you look at all the circumstances, whether, including the mental condition with penal interest, whether or not the person would reasonably understand that it was against their penal interest, a motivation to lie, all of these different circumstances might play into, any determination, I think, as to whether a statement was sufficiently reliable or probative.
I don't see how a judge confronted with a statement close in time to the event that would, if believed, exonerate the defendant, could decide simply based on the fact that, oh, she was just in an accident, I'm not going to put it in. I mean, isn't that exactly the stuff of cross-examination and argument?
It can be, Your Honor, but it's also, it can be a hurdle that the defendant needs to overcome in order to put that evidence in. I mean, of course, we see it all the time with criminal defendants who are in a different position than another witness, but we all the time keep out very probative statements because of the circumstances in which the statement was made, including in this case. I'm not saying at all they're in the same position, but the analysis is not entirely different in terms of whether or not this is a probative, reliable, relevant piece of hearsay. I mean, keeping in mind all the time, of course, that this is an exception, that this evidence is not supposed to come in, that we're dealing with exceptions to the rule, and we're dealing with the question whether a trial defense counsel was constitutionally ineffective for not believing that it fit within the exception to the rule in this case. And it's a very different analysis in that way than a trial analysis.
Constitutionally ineffective for not trying to get it in, right? He did not try to have it admitted.
Well, because he did not think it was admissible. He said that he did not think it fit within the elements for any of the hearsay exceptions, or that's what he said in his affidavit. So, you know, we say all the time that counsel is not required to make futile motions. Counsel decide all the time to bring certain arguments or not.
But this judge obviously concluded that the motion would not have been futile. The attempt to introduce it wouldn't have been futile because it would have been admissible on 2 grounds.
He did.
Where you have a trial judge saying that, again, unless that was manifestly unreasonable and no judge could possibly reach that conclusion consistent with the law, doesn't that kind of resolve the performance prong and move you on to prejudice?
Except that I think that the judge was wrong in his analysis. But moving on to prejudice, there was some discussion about the standard and the appropriate considerations. And I think, as always, there's a middle ground to be reached. Certainly, there is case law that says that the motion judge is not supposed to make credibility determinations in assessing a motion for new trial. But and I'm sorry, I don't have a case to cite you, but and I'd be happy to provide it afterwards. But certainly, it's also clear that the judge does need to take some account of the circumstances of the case, and there has to be some weighing of the evidence that goes in, because otherwise you can't.
I don't see an argument in your brief that responds to the defendant's argument that the excluded admissions by the victim were of a different quality or higher caliber than the testimony offered by the defendant's friends. So what's your response to that?
Well, my response is that, and it's probably contained more in the individual arguments, certainly it is of a different quality in a way, in some ways, because it is the victim herself talking, but it loses a lot of its weight, I think, due to the circumstances of her mental and physical condition, particularly taking into account the fact that she later was asked to lie by the defendant.
So are you saying the jury wouldn't have believed it?
I think, Your Honor, that if you just took the statement on its own, that certainly jurors could have credited it. I mean, I think it was very weak given her mental and physical state. But I think that the real point in this case is that is kind of the, I hate to say overwhelming, because I try not to overuse that term, but it was a very strong physical case. I mean, and there were just 2 points, but they were super relevant and probative in this case. One was Mike Brophy seeing the defendant get out of the driver's seat of the car just after the crash. The second was the physical condition of the car itself, where the victim was, the passenger side.
So,
Loss of blood, no blood on the other side, the defendant not injured.
right, so the defendant said in his closing argument at trial, how does the Commonwealth explain the injuries to that 3 of Ms. Kimball's fingers on her left hand were traumatically amputated? What is there inside the vehicle, if she's sitting in the passenger seat, that could cut 3 fingers off of her left hand? And isn't it at least plausible that that was because she was in the driver's seat and her left hand was, you know, this is a July afternoon, windows may be open. Isn't it plausible that the Jeep landed on her when there was the rollover?
I don't remember precisely the argument that was made, but certainly there was no evidence in this trial. There was no medical evidence or discussion as to how her fingers might have been amputated.
Yeah, but when we're talking about what could have affected the jury and looking at the arguments that were actually made to the jury, you know, it is a little bit of a mystery how 3 fingers on her left hand were cut off.
I didn't understand the evidence to be that her 3 fingers were cut off. I understood it to be that her hand was crushed and that resulted in the amputation at the knuckle of 3 of her fingers. What does the record show us on that?
It was my understanding they're referred to as being amputated. I thought that it meant that her fingers had been cut. But I can't say that I've really thought about that distinction.
I just want to make sure you have a chance to respond to this point about Roberio and whether the judge in judging prejudice on an ineffective assistance claim can make a determination about credibility, or whether once the judge has determined that the performance standard has been not satisfied by trial counsel, the determination of the credibility of the evidence that wasn't offered is for the jury.
I think that it is a very delicate balance in that case. In that case, and as I said earlier, I do think that the court has made clear that you're not supposed to make credibility determinations, but I think the courts have also said that you need to the judge needs to make some assessment in determining prejudice as to how the evidence might have affected the other evidence in this case.
So let me ask if you agree with this, and I understand we're out of time, but would it be proper for the judge to say, okay, even if this evidence that due to ineffective assistance wasn't introduced, had been introduced and believed, it still wouldn't have been likely to affect the jury's verdict because, for example, the Commonwealth's case was so overwhelming?
Yes, that would certainly be appropriate.
So that's a way of saying, okay, even if the jury had believed this, it wouldn't have made a difference. But saying the jury wouldn't have believed it is really kind of getting into the sphere of the jury.
Yeah, I appreciate the problem without having any good suggestion as to the answer, Your Honor. But it does not seem to me that a judge can completely divorce the weight of the evidence that was omitted, and that may take into account some assessment as to how probative it was, how believable it was, and that is a delicate balance for a judge to meet. But it's hard to believe that they have to completely divorce their analysis from whether it was weighty or not.
What a jury might do with particular evidence too. I mean, a jury could say, I believe she said that, but given everything else, she was obviously confused by it, by the circumstances. And besides, she likely was under the influence of heroin. They could have addressed it in a number of ways. It doesn't have to be complete acceptance or complete or completely just not believing.
That's true. That's true, Your Honor.
All right, I think that we understand your argument. Are there any further questions from the panel? Excellent. We'll have to leave it there. Thank you very much.
And we are live and on the record.
Excellent. We're continuing the November 13th, 2020 sitting of the Appeals Court. I'm Justice Henry, joined by Justices Englander and Sachs. This is case 2019-P-0787, Commonwealth versus Cowan. We'll hear first from Attorney Hickson.
May it please the court, in this appeal, I think it raises an initial serious constitutional matter. And that is how the judge handled his instructions in terms of the facts presented to the jury, and they're viewed as facts by the defendant. The verdict slips in this case were marked, and they were very specifically marked. And I would suggest that they were marked to the degree and in conjunction with the instructions that it was improper.
Counsel, just to set the table, we have 10 indictments that are identical, right? Other than the number. And
yes.
Then the judge was making a verdict slip for each allegation by the Commonwealth, right?
Yes.
And I think if the judge had not done that, we would have a specific unanimity problem because we wouldn't know that the jury all agreed on certain conduct. So, and the Commonwealth argues that. So what do you say to that?
Well, I say, first of all, the work of the grand jury, that is how the indictments were issued. So that is the work of the grand jury. It is not the judge's, that certainly does bring in problems, but that's why you would have a specific unanimity instruction. In terms of putting them on the...
Counsel, how could he give a specific unanimity instruction without giving them some direction as to which crime was alleged with which indictment?
Well, I think that there are specific instructions in terms of what constitutes an indecent assault and battery, and the jury could have been instructed saying that you have to find a specific of one of these acts conduct to find a defendant guilty beyond a reasonable doubt. but I would suggest that you're leading the jury when you do that, and that is a much more significant problem.
So is it your argument then that the way that he needed to handle this was to present 8 different charges to the jury? I'm sorry, 8 charges to the jury which were identical? I'm really struck. Let me just tell you where I'm coming from so that you can address it. I think that this is exactly what he needed to do under the circumstances, to separate out and say these are separate crimes.
Yes.
What do you think he should have done?
He should have instructed the jury and said that there's indictments here, and you have to decide whether simply whether the defendant was guilty or not guilty of the number of indictments, whether it was an indecent assault and battery or not. I mean, he can't be that specific in this case.
Whether
I would
it
point.
was, but I mean, that just sounds to me like you've literally cut the jury loose. They have no idea what's the difference between these 8 separate crimes they're being asked to rule on.
Well, there was a procedure for that, and it wasn't followed. There could have been a bill of particulars. There could have been an instruction for more further instructions, and that this didn't happen. There could have been a
didn't file a bill of particulars. The defendant didn't file a motion to dismiss on the grounds that they were duplicative. The defendant didn't ask for any particular instruction, and the defendant didn't object to the instructions that were given, right?
Yes, that's the record, and that's why I raise an ineffective assistance of counsel claim as well. But that said, the judge couldn't take a unilateral action as he did. And I would point out that in terms of verdict slips, I think the use of verdict slips is troubling generally, and specifically in this case. They're really supposed to record a guilty or not guilty verdict, and that's supposed to be it. These are not special verdict slips or that sort of thing where you break down a case like in a civil case, more specifically, or sometimes even a criminal case. The use of these it's not in the rules of criminal procedure. And as I just mentioned, in terms of bills of particulars, if you want specificity, there's ways to get specificity. And this simply wasn't.
The rules of criminal procedure contemplate different verdicts on each charge.
Certainly.
Okay. So when you say it's not in the rules of criminal procedure, surely it's in the rules of criminal procedure that since you're going to get a different verdict on each charge, the judge can instruct as to each charge and
Sure.
as what is alleged with respect to each charge. No?
Well, all that is alleged is an indecent assault and battery. That's the allegation. That's the allegation the jury returned. No more, no less.
Crime between 2007 and 2011.
Yes.
That's what you would say, right?
With the exception of a rape.
I understand I understand the concern of defense counsel that they may not want tactically to separate out 8 separate crimes that have been indicted, and that can be an issue for them. I understand that, and that you would prefer it just be one up or down, especially when the defense is uniform, right? As it was in this case.
Yes.
It didn't happen, right?
I want the jury to be unfettered and can be able to consider everything. And that
Would it just preclude them from considering anything?
no, they should consider everything according to the jury instructions, including reasonable doubt.
I'm asking you how the descriptions of the different indecent assault and battery charges limited the jury from considering anything.
I
Do you
don't
think that there are additional claims of indecent assault and battery that they should have considered but were steered away from?
No, they should have considered all the evidence. All the evidence.
All right, and I'm asking you, what was done with the jury slips and the accompanying instructions prevented them or steered them away from considering all the evidence? What evidence were they discouraged from considering as a result of what was done?
They were discouraged from considering evidence other than the evidence that's stated in the verdict slips. In other words, the verdict slips were very specific.
Okay, so what specific evidence were they discouraged from considering? Or what category of evidence?
Other touchings that could have concerned, whether the touchings occurred at all, whether was credible.
Well, the judge in his instructions said, these notations are to hopefully make your job a little easier and to describe the event that is alleged by the Commonwealth. The judge didn't say these happened.
The judge said, these are what the Commonwealth alleged to have happened. If the judge left something out, if there were 10 or 15 incidents that could have been indecent assaults and batteries, and the judge somehow limited the jury to considering only 7 of those, I don't see how the defendant was prejudiced by that.
Well, because when the judge gives an instruction like that, the judge is saying, look, this is what's really happening in this case. This is what you are to consider in this case, this sort of touching in this place. And it just follows the Commonwealth's evidence completely.
He describes it as these are to describe the event that is alleged by the Commonwealth. I don't see how that says this is what really happened.
Well, I think that when you organize the evidence in that specific way, and as the last jury instruction, I think you're very much pointing to the Commonwealth's case.
But isn't that what, I mean, the Commonwealth is saying certain acts satisfy the crime charged. And so the question for the jury is, do you agree or disagree, right?
That should have, yes, and that should have been the end of the discussion there. And the jury verdict slip should have said no more.
Well, so the Commonwealth cites Commonwealth versus Monzon for the idea that it is permissible for the verdict slips to specify the act charged, and they give an example of the hand touching a hand to a body part. How is Monzon different, or does it not stand for the proposition the Commonwealth argues?
I can't say specifically remember that case right now, but I think it would depend on what the indictment's language is. Okay. Now, if the indictment made a specific to wit or by means of allegation, then that would be acceptable. That would be the work of the grand jury. In a jury verdict, when the trial judge does that, and one has to appreciate, the presence of the trial judge directing information to the jury like that, how important that is, that would be wrong. I don't believe in the use of jury verdict slips like this.
Say you don't believe in it. I think what you're arguing to us is that it's in some way unlawful
Yes.
for the judge to have done this, and I'm struggling with why that is.
Because
You have a grand jury work that says 8 indictments, indecent assault and battery, child under 14 from 2007 to 2011.
Mhm.
Doesn't the prosecutor have the ability to come to the judge before trial, along with defense counsel, and say, this is how I break down these 8 indictments. They are, in the living room, touching the X, in the whatever. Doesn't the prosecutor have the ability to do that, to further define what the allegation is?
yes,
Okay.
but
Isn't that what happened here?
no, it wasn't done in the right manner. If there was a bill of particulars or a stipulation or something legally
But can't we
recognized.
infer from the fact that that's what the judge laid out,
Mhm.
and that no one objected, that
Yeah.
that's what happened?
Well, I think the Commonwealth might argue that, but I wouldn't accept that because this is now in the form of a jury instruction in a marked document, and it goes to the jury in that way. I don't think the
Counsel, let's make this easier. Let's say that there's an indictment, just like one of these indictments, okay? And it doesn't give a particular act. And then the victim testifies and says, gives testimony that supports 2 different acts, hand on one body part, hand on a different body part. If the judge doesn't tell the jury which one it's considering, how do we solve the specific unanimity problem?
Well, there simply has to be the judge. I'm not trying to say handcuff the judge at all. The judge could say you heard evidence. It has to be much more of a general, non-specific category. You may have heard evidence of a touching on this body part or that body part, and what constitutes an indecent assault and battery. The jury have to find that the Commonwealth proved beyond a reasonable doubt that one of the defendant intentionally touched one of the complainant's body parts in this case in that manner. I would leave it much more open than it is.
So just going to the one of the other arguments, the Commonwealth argues it was a strategic choice of the defendant's counsel to elicit testimony about the investigation from several witnesses, and that really that has to be addressed through a motion for a new trial. What do you say to that?
Well, in terms, the Commonwealth versus Stuckich is very clear on this case that evidence, and I've been a trial attorney, both as a prosecutor and as a defense attorney, that you try to make, if you don't have specific evidence, and this case is difficult in that way for both the prosecution and the defense, that you can't, it's hard to defend against everything. There's no issue about identification or access. So both parties are gonna use and make evidence wherever they can. It's like who spoke to what to whom, and then what did you do to this and that. So it's kind of like almost like a quasi evidence thing that you would rely on to like break the tie of who's telling the truth when both people just unilaterally and categorically deny. Well, the defendant categorically denies he touched her. She says she touched him very specifically. So you just, as a trial attorney, you just try to grab whatever you can. But in Stuckich, it says that is improper. You can't use that. That is not evidence. That is not probative evidence in this case. And the prosecutor did that, and the defense attorney went right along with it. Now, I think from a defense attorney's point of view, sometimes you're curious in terms of what happened. And you don't always know that through the discovery process because it's not necessarily in the police report. So you might just ask questions and look and then explore, but you're actually hurting your case. And that's what happened.
Can we switch to a different topic? The Rule 17 issue.
Yes.
Are you making an argument that I understand you have an ineffective assistance argument. The ineffective assistance argument is based on the fact that counsel did not present the best argument they could for getting access to the therapist reports, right?
Yes.
But are you also arguing that the judge erred in not allowing the access in the first place?
Yeah. No, I can't say no, not in the first place. It was in the second place when it was identified by the motion for new trial attorney that the complainant in this case had spoken to the person indicated in the brief that you talked about the incident. That's right. Where the error occurs, and it goes to the reading of Commonwealth versus Lebrad. I say Lebrad says that once there's evidence that the complainant talked to a person, those records can be viewed. I think I don't speak for the Commonwealth, but I think they say that you have to show more.
Those records must be allowed to be viewed on motion, yes. Right?
Yes.
That's your position.
But does Lebrad dispense with the requirement from Lampron that they have to be relevant? That's a threshold determination made by the judge? Okay, so if the judge says, well, what's in these records is not relevant to the defendant's theory of the case, it doesn't support the defendant's theory that the victim had fabricated the allegations, there was nothing in them that was inconsistent or had any conflict with the victim's story, so couldn't the judge make the determination that they're not relevant and therefore no right to expect them?
No, and I would suggest that's not that is now forbidden under the case law, that a judge cannot make a strategic calculation. Insofar as the court followed that, it's my understanding that the Supreme Judicial Court no longer follows that. And once there's discussion, then it becomes the defense attorney's obligation and his duty to decide whether these records are useful to the defense or whether they're relevant or not. There is a discussion.
To be clear, the judge never saw the records, right? They were never produced.
Yeah, my understanding is that they were never produced because he simply denied the records, and that the privilege assertion, an assertion in terms of privilege was made. So I'm asking the court to remand that in that further proceedings in the attempt to summons the records and that he be allowed to view the records. Whatever whatever precisely happens in the trial court has to be sent back to the trial court in light of the proper rule.
All right, counsel, your time has expired. Are there any further questions? I think we understand your arguments, and now we'll hear from the Commonwealth Attorney Rose.
Thank you.
Good morning, Your Honors. May it please the court. Megan Rose for the Commonwealth. I would first like to start out with, since we first started, my brother first started with the jury instructions and the verdict slips. In this case, I think it has to be argued that what happened here with the verdict slips and the jury instructions was exactly what needed to happen. First, we're at an we're at a substantial risk of miscarriage of justice standard because trial counsel had 4 separate opportunities to object to the verdict slips and didn't do so in this case. And he specifically confirmed that these verdict slips were accurate and appropriate. And then the
But what
trial
do you-
court,
Defense counsel seems to say this really went wrong at the grand jury stage, that the indictments should have laid all this out. What do you say to that?
I think that at a grand jury stage, I think it's common that the grand jury would indict just based on certain charges and not necessarily lay them all out. And then it's for the Commonwealth later to narrow them down further. And that's exactly what happened in this case. And trial counsel was aware, and so
It's
was.
common for the grand jury to indict. Aren't the indictments provided by the prosecutor?
Yes, Your Honor. I think, however, I believe in this case that the indictments were more simple. And that
The prosecutor's deciding how to indict this case, right? I mean, they're deciding what to ask the grand jury to do. The grand jury isn't coming up with these 8 identical indictments on their own.
no, Your Honor, no.
So why doesn't the prosecutor divide that up at the time of grand jury? Why indict 8 things that look identical, leaving us with this problem that Attorney Hickson is bringing to us, which is without the judge doing something, we have no idea what the separate claims are.
Correct, Your Honor. But I think in this matter, and I think what happens over the course of many other cases, is that some further evidence is discovered in the investigation after indictment. And that's probably what happened here. I wasn't the prosecutor who did the indictments in this matter in the grand jury, but I would assume that that's what happened in this case. And I think it's common procedure and common practice.
I can understand that you can make your case better after indictment, but at some point, the jury has to be told what's alleged. And something that simply says 8 identical, an indecent assault and battery on a child under the age of 14 between 2007 and 2011 isn't going to tell the jurors anything. They are not going to know the differences.
Correct, Your Honor, and I believe that's exactly why special verdict slips were provided in this case. And the court was very clear on 3 separate occasions that these are the Commonwealth's allegations. These are the Commonwealth's allegations. At no point in time did they say that this is what I believe, or the trial court didn't say this is what I believe, these are my beliefs. These are the Commonwealth's allegations, and these are only allegations, and these allegations are not to be used as evidence. And it was very clear in the jury instructions multiple times throughout the case. And jurors are presumed to listen to the jury instructions.
In the opening, I apologize, I did not read it. Was it clear did the prosecutor lay out what the 8 different charges of indecent assault and battery were?
Your Honor, I'm not exactly sure in the opening. I can't say to that, I'm sorry. But I do think that based on the jury instructions, specifically from the trial court, that these were the Commonwealth's allegations.
One of them was directed out, right? One of the original indictments for indecent assault and battery was directed out.
Yes, Your Honor.
And so.
And the Commonwealth had agreed to that.
Right. And so that must have been an indictment that was identified as corresponding to a particular set of conduct.
Yes, Your Honor. That was one of the ones that had happened at the hotel.
Hotel. Okay.
There were 2 allegations at the hotel. One of them was directed out.
So
yes, Your Honor.
How did the parties and the judge decide which of the 8 indictments should be directed out?
I think at that point in time, the verdict slips had already been produced, and they had indicated that I can't exactly say what that verdict slip said, but it said hotel and whatever his inappropriate conduct was at that time. That would have been the Commonwealth agreed.
This supposedly happened at the close of the Commonwealth's case in chief. So I don't know whether the verdict slips were ready at that time, but we can check the record on that.
I believe on page, where is it? I think it's transcript 3, page 124. I want to say that's where it's discussed. And it indicates these are the Commonwealth, how the Commonwealth had narrowed down its evidence. And these were specifically given to the clerk for the special verdict slips.
I see.
If there's no further questions.
So switching to the therapy issue, I take it because you briefed the issues in a different order from the defendant and you briefed the therapy issue first, that you think that's his strongest argument?
No, Your Honor, I think the reason simply that was done was simply because I think that the motion for new trial should have went first as opposed to the direct appeal, which the two were just consolidated. Not necessarily that I thought one was stronger than the other.
And so where we've got this change where that now there's evidence that the victim has talked to the therapist, what showing should he have made that you think didn't get made here?
I think he would have had to produce or showed some sort of indication that there was either any kind of inconsistent statement or that she had said some kind of coaching was done. That was the defense, that, you know, none of these allegations ever occurred. The defense was that she was mad at her teacher for an assignment and she came up with these allegations. And then she realizes, oh, I need to talk to all of these different people and I don't want to make a full accusation to any of these people. So she doesn't. And then it's not until she gets to her therapist, who's then coached by her therapist, who then a year later makes these accusations and indictments are then brought. I think that you would had to have shown, based on the statements that were made, they were all corroborating statements with what she had testified to.
So just to back up, because I think counsel has laid this much out correctly. You have one witness, you have no physical evidence. The one witness says, I was abused many years before in this way, right? And it is clear that she had a conversation with her therapist about what the abuse was. And the Commonwealth's position is the notes of those conversations don't have to be produced to the defendant. Unless the defendant can show something about what was in those conversations, which they're not being given. That's your position.
Not exactly, Your Honor. No, I believe that this happens in many cases when you have a Rule 17 issue where how can I argue I need these records if I don't know what's in these records, right? So in this, but you have to prove that it's relevant to a point in issue.
To be relevant, of course it's relevant. She's saying he abused me in the following ways. We know that she had a conversation before she took the stand many years before with someone else in which she described that abuse. Of course, what's in the records is relevant.
Relevant to this specific issue that he needed them for, which was for the coaching.
No, why do we have to limit it to coaching? The defense was it didn't happen. And you know, there are 8 different allegations here. So maybe she does, what she has indicates that 4 of them didn't happen. But we don't know because the Commonwealth has completely precluded the ability to get to that information.
Well, it's not necessarily that the Commonwealth has precluded it, but it was a Rule 17 issue. They were privileged documents from a third party.
The Commonwealth objected, right?
Yeah, correct, Your Honor. The Commonwealth did object.
Okay.
And the Commonwealth never had access.
The Commonwealth not objected. I know it's a third party document, but that the document would have been produced.
Well, they were privileged documents, which the victim had asserted for privilege.
Yep. Okay. So the privilege had to be decided independently of the Commonwealth's position.
Agreed. Yes, Your Honor. I believe so.
So the language sorry, go ahead.
No, go ahead. You go ahead.
The language I see in Labrode, which says why the records there should have been turned over, that seems to be critical, is in the conclusion section on page 1039. It says, and because the defense was based on the complainant's allegedly conflicting and inconsistent statements regarding the assault. So if there had been evidence that the that the statements the complainant made to the therapist conflicted with or were somehow inconsistent with other statements she'd made that she was going to make at trial or that she'd made to other people to whom she'd reported, you'd agree that the defendant would have a right to see or counsel would have a right to see those records.
I do, Your Honor. I do agree to that. I
Well,
think Lebrad is obviously on point, and it's the case that we need to look at. And in the conclusion section, as you had stated, it's a two-part thing. It says, I mean, I could say it again. Excuse me. Because the complainant's explanation of how and when the alleged sexual assault occurred was relevant and had evidentiary value, either as impeachment material or substantive evidence. And I think the key word is and, because the defense was based on the complainant's allegedly conflicting and inconsistent statements. So here what we have
being a holding. We don't have to read it that way. I understand the argument, but I mean, that just simply made it easier for the judge to say under those circumstances that they had to be produced. But you could take the former and say, once the case is about what the complainant said, it's relevant. And doesn't Dwyer suggest that really the judge doesn't have much discretion when you're dealing with a criminal defendant once relevance is established, once the four categories are established, which they are here, by the way.
And I would excuse me, but I would argue that under Lebrad they aren't. In
which category is missing? It's not relevant.
Number one, and I think relevancy, and I think according to Lebrad,
counsel, in any other context, relevance is so broadly defined in our cases that it has to include a conversation between the complaining witness and anyone prior to trial about what she's complaining about, right? In terms of relevance.
Well, is it relevant to the defendant's case?
And the Commonwealth's argue is that in this matter, the defendant didn't make the relevancy connection with his defense and in his case.
It might be relevant to the Commonwealth's case. I mean, because it confirms that she told her therapist that she was abused, although she wouldn't call it rape, for example.
And they were exactly, Your Honor, and they were all corroborating statements to what she had already testified to at trial. And I think it's important to know
what she said. We do not know what she said to her therapist. You don't know, and I don't know. And
I think it's also important, which hasn't been discussed, is what standard we're at. And I think we're at an abuse of discretion standard here with a denial of a motion for new trial and also a denial of a Rule 17 motion. And I think when the judge looked at Lebrad, which this trial court did, and specifically indicated in his decision, the statements in the same interview leave no doubt that the victim did discuss her allegations. However, nothing in the evidence presented by the defendant remotely suggests that therapy records will show coaching. And then he cites to Lebrad later down in his conclusion.
That's coaching. It's not necessarily inconsistency or inconsistency with any of the 10 different indictments, which at that point, by the way, nobody knew what they were, just that they were something that happened that was called indecent assault and battery between 2007 and 2011. Tying this back to the problem that we also have. I mean,
the defense has never suggested any kind of inconsistency, either at trial or in their motion for new trial.
They don't know what's in the records. They asked for them and they were denied. And isn't that what Dwyer deals with? It says, boy, it's awfully tough. I think we've made this standard a little too hard.
And the Commonwealth's position is that Lebrad is the holding case, and in the trial court did not abuse his discretion in reading Lebrad.
So help me with this, because I understand the argument. We would not be in any position to say that the verdict needs to be upset here. Because we know no more than anyone else does what was in those records, right? So the question is, it's unlike most cases where we see ineffective assistance in that and this is what happened in LeBron as well, though, the most that could be done is send it back so the judge can look at what was in the records, right?
Yes, Your Honor.
And so what's our standard for deciding whether they properly decided not to look at the records?
I think we're at an abuse of discretion as to the denial of the motion for new trial and the denial of the Rule 17. As to once we get, if this court determines that then should have access to those records, then we're at an ineffective assistance of counsel standard. And we have to see whether those records would have made difference, and to prong 2 of Safarian.
Counsel, I see your time has expired. I just wanted to ask you briefly about the investigatory questions. In the briefs, everybody refers to 3 different questions the prosecutor asked, and you say as to the second and third questions that it was just clear as a whole that the defendant had made a strategic decision not to object. But my question to you is different. Were those questions improper from the prosecutor? The second and third questions.
I don't think necessarily that the questions were improper, but I suppose that the answers that were given were beyond, were what first complaint discourages and were beyond the scope. I don't think necessarily that the question itself was improper, Your Honor.
Does anybody else have any questions? Thank you very much, counsel. We'll have to leave it there. Good arguments. The case is submitted. Just want to ask the department and the child, you're splitting your time. It looks like 9 minutes and 6 minutes.
Yes, Your Honor.
Okay. So with that, Attorney Cowan, please proceed.
May it please the court, Attorney David Cohen on behalf of the appellant father. This court should vacate the decree terminating father's parental rights and remand the case for a trial court hearing at which father should be a party for a new determination as to exactly what plan, what custody or adoption plan is in the child's best interest, including further consideration of father's proposed plan of paternal grandmother. Now, before I address the 2 principal reasons why this court should do that, let me emphasize that father does not suggest relitigating this entire case from the beginning. Father concedes that as of trial, he was incarcerated and unavailable or unfit into the foreseeable indefinite future. But father, there must be a remand and a vacating of the TPR, of the termination decree, until father gets a hearing where the trial court, has not already erroneously issued a decree based on its approval of an insufficiently detailed plan, and father has standing and an opportunity to present his plan and to put it forward for full and even-handed consideration.
So, counsel, as I understand it, your argument that you're presenting is based on a reading of the statutes, Chapter 210, Section 3C. Is that right? That the determination as to the father's ability or terminating his parental rights can't be divorced from the adoption plan.
That's correct, Your Honor. They're the factual legal issues in this case regarding father's asserting that the plan was legally insufficient and there was an abuse of discretion by the trial court, but that's a prerequisite to maybe what this court wants to talk, may perhaps want to talk more about, which is that contrary to the this court's holding in Barik, the court's analysis on the particular point in that case, which we just referenced, is that a termination of parental rights decree may not stand or be affirmed separately from a legally adequate, properly approved plan in child's best interests. In other words,
I want to be clear, to rule in your favor on this point, we would have to say, and I don't know how it's pronounced, but I'll go with Barik since you did.
Sure.
Would we have to say that Barik was wrongly decided?
Not in its entirety, but in the sense that it in remanding the case without vacating that termination decree in Barik, that's not consistent with the statutory scheme or kind of the great bulk of existing case law at the time Barik was decided last year. So
help me understand that. Go ahead, Judge Henry.
Well, so is your understanding then when we remanded in Varique that the father or the parent, I don't remember which one it was, he was a father, that the father in Varique was not permitted then to participate on remand because his rights had been terminated?
I believe so, Your Honor. I would have to check also, but I believe that's right.
Is there anything in Varique that speaks to that one way or the other? I couldn't find anything, but I'm asking you and ask the other parties when they argue whether they see anything.
I do not know offhand, probably should, but I can check for this court. But there is in other cases, Your Honor, such as Dora references
That was a visitation case, right?
Dora was a competing plans case.
Okay.
So,
Counsel, what is the policy reason why you can't separate a determination terminating parental rights from a determination as to the acceptability of the plan?
well, there might be several, but one essentially might be a child could become a legal orphan. It may be the informal term is that if there is no plan that is in the child's best interests at the time that the court approves the plan and then approves the termination of parental rights decree, the child's best interest will not necessarily be served. The child could languish in foster care for a long time. Older children are harder to find placements for. These kinds of policy considerations inform or are likely the underlying reasons for the statute. So the plan does not have to be fully developed, but Varique itself says, it must specify the type of adoptive parents and characteristics of the home environment best suited to the child's specific needs.
The interesting thing is so the statute only says, and shall also consider the plan. So you can't rest your argument. I mean, here the judge considered the plan, right? You can't rest your argument really on the statutory language. You're resting your argument on a gloss that you take from Varique on that statutory language.
No, Your Honor, I would disagree. The statutory language is plain statutory language. Consider and, so consider current parental unfitness into the future. That's essentially the adoption of Carlos analysis and the sufficiently detailed plan. That's the Dora analysis. I mean, Dora, if you parse out the statutory language in Dora, that's the result you arrive at. I direct the court to Dora at pages 476 and 477.
You say the gloss on the words shall also consider comes from Dora, not from Varique.
I think it comes from, I don't know about
You're saying consider means something more than that. Consider doesn't just mean you have to look at it. Consider means what they say in Dora.
No, in order to have the decree, the trial court has to approve a plan that is in child's best interests. So the consideration of the plan is in furtherance, the trial court's consideration of the plan is in furtherance of approval of a plan in child's best interests. And that's what has to be done. And it can't approve a plan in child's best interests unless there is a plan in child's best interest.
So Varique, we see how the statute envisions things being done. And Varique says, okay, when things weren't done that way, here's what the remedy is. You don't have to go back and vacate the whole decree. You just vacate that portion approving the department's plan and send it back for the department to submit a better plan. Here, I think I get your argument that the plan here was not much different from the plan that was found deficient in Varique. But given that since then, the department has found that the interstate study has come through and the department has, at the permanency hearing, determined that this is an appropriate placement, and it may already have occurred for all we know. What would be gained here? What does the father have to say about this placement in Tennessee that would be of value that would justify a remand? There may have been error here in approving the department's initial plan, but in light of subsequent developments, is there prejudice?
Well, I can point to a few items. I can't fully flesh out what father would present at such a remand hearing, but it's really not enough for the appellate to say that the father was not a party to contest any of the assertions in August 2020.
Well, was
And
there,
they, you know, father is arguing here that they be stricken because they're outside the record on appeal, even though DCF has submitted them. But you know, since we've all read them and you're referring to them, you know, they have there's some competing information in there about the child's needs and this possible placement, and that this possible placement, despite apparently being approved by the court in August 2020, is not in the child's best interest, and father needs to have the right to contest those things. So for instance, the child's ongoing issues with, you know, there's quite a lot of material in there about child's ongoing issues with her specific needs, that, you know, this, the trial court here said the child has no special medical needs. That's finding of fact 128, but the child certainly has specific needs, particular to her situation, her health and development, wedding, incontinence, lying issues, and that she had made minimal progress as of trial, and apparently as of, despite therapy and foster care and you know, for the last year or so. There is also information about what that proposed resource, what training it would be, that proposed resource would be getting from DCF and how it would address those needs. And none of that information was available
Is it
at
clear
the
the
time the
court
trial made it.
had
Trial court made
jurisdiction
its
to do what
decision.
it did in 2020?
I beg your pardon, Your Honor. Would you repeat the question?
Is it clear that the court had jurisdiction to do what it did in 2020, given the pendency of this appeal? I don't know the rules or law on it, but it strikes me as odd that we're being presented with something that happened during the pendency of this appeal as if it moots our jurisdiction.
I don't think it's a question of jurisdiction, Your Honor. It's certainly possible that this appeal could have occurred before that August 2020 hearing.
Ordinarily, when the case goes up on appeal, things don't happen in the trial court, ordinarily.
but 29B requires things to happen in this instance, doesn't it?
Sorry?
Yes, Justice Sachs, 29B hearings do happen every year, annually according to statute. That's 11929B. And indeed, things do sometimes happen in the trial court beyond a termination of parental rights decree when these cases come up on appeal. Plans that are in effect are dropped. The child may want something differently. An adoptive resource may drop out. That's all fine and part of the process. But this court can't, you know, on appeal, the appeal is what happened at trial and whether there was legal error. And
But
here there
sometimes
was.
things happen after trial that moot an appeal. And so what I'm trying to get at is has
Not
what,
usually in the trial court. That requires usually something that specifically allows it to happen.
Sometimes things, Justice Sachs, do happen after an appeal is entered that moot an appeal. And Justice Englander, I'm still not, I don't quite understand the thrust of your question.
Well, okay, we'll sort it out then. But look, the general rule is when a case goes up on appeal, the trial court is divested of jurisdiction. That's the basic rule. And then there are exceptions to that rule when things have to happen in the trial court while the case is up on appeal. The reason for that basic jurisdictional rule is because you don't want the trial court doing something that literally changes what's up on appeal, which it's being argued to us is what has happened here. Now, it may well be that this is an exception in these circumstances because, you know, we still need to take care of the children, right? And that there's law that says, even though this case is on appeal, you still need to take care of the best interests of the child in the meantime, and therefore the court is not divested of jurisdiction. But that was my question was, do we know?
So no, the court was not divested of jurisdiction. In care and protection cases, Justice Englander, in particular, review and redetermination hearings under 119 section 26 are routinely can continue on a separate track or apart from the appeal. The parties will be obligated to notify the appeals court. I think that's custody of Deborah, but I don't know the exact case. So you know,
I guess the question though, counsel, is if we say here that in a normal circumstance, if we were to follow Variq, we could affirm the termination and we would remand. But now the remand, but I'm unclear what would happen that's different now. Why would we remand in this circumstance?
Father would be at that remand hearing to
Right,
contest.
but I just asked you if his rights are terminated, would he be at that remand hearing if we follow Variq? And you said you didn't think Father would be there.
Right. If you follow Variq, it's my understanding, although I don't know anything express is said in Variq. If you follow Variq, then Father's rights would be terminated and he would not be at that hearing. And that is why you should not follow Variq in this case.
Okay, but let's assume with me for the moment that we follow Variq. Then why should we remand now in light of the further proceedings? Or are you saying we should remand and the judge should say nothing else needs to happen because I just had this hearing in August? What should happen?
Neither, Your Honor. You should vacate the decree.
No, I understand what you want, but if we disagree with you, do you want to have any input on what we do with the remand? Or do you want to just leave us unguided by your input? Well, I'm asking for your input.
Sure. If you disagree, then you should give guidance to the juvenile court to further consider the potential flaws in the plan it approved and further consider Father's proposed plan. I mean, I see I'm running out of time here, but
why should the court reconsider Father's plan when the court already found it was not in the best interest of the child because Ms. N was not sufficiently committed to the child as opposed to the father?
Just say grandmother, okay?
The grandmother, well, the trial court did not consider certain things in the paternal grandmother's favor, including that she followed DCF's instructions not to discuss the case with the father, that she identified a therapist, that she would obediently follow the trial court's orders and set boundaries vis-a-vis the father. It really didn't consider.
That's an argument either that the judge committed clear error or that the judge committed enough clear error that that the application of the law to facts was wrong, right?
It's part of an argument that really there was no plan before the trial court at the time, and that's what's on appeal here. You can't, after the fact, go back and say, well, we just cleared all this up without Father being there to present his case fully and to poke holes potentially in the case that the department is proposing. I mean, clearly at the recruitment stage, or at the trial court stage, this court, the maternal relative that's now a potential placement here was really completely out of the picture. I mean, she's mentioned briefly in the January 7, 2019 original adoption plan proposed by the department. This is at Record Appendix A 157, 159. And then we have a hearing. That's the hearing on the merits in February 2019. And then a few weeks later, DCF sends a letter to this relative in Texas saying, we've closed the ICPC. You didn't respond. This resource, sort of forswears DCF and the whole process in an email to DCF. She wasn't a real option on May 10th, 2019, when the trial court issued its decrees.
But
that's legal error.
Actually back as a real option by the time of the reopening and the modification, right?
She was back as an option by the time of the amendment. That's after the decree. Now there were statements that well, we don't really know if this is ever going to happen because right. She's, I mean, it was very vague and particularly there was no information about the particular. This is a child who's going to a trauma-informed therapist as of January 2018, and DCF's plan said about the grandmother that the grandmother would be unable to support the child through the trauma she suffered, but it said nothing about how DCF's proposed resource or resources, if you include the grandmother, would do so. There was nothing in there, and there really needed to be. There was nothing about we need to find a placement that can meet the needs of this child. It was just, well, we'll recruit somebody.
So counsel, on assuming for the moment that we agree that Variq we are not going to overturn Variq. should we clarify that as long as the parent's appeal is pending in these further proceedings that will be happening, that the parent should be permitted some role until the underlying decree is either affirmed or reversed?
Yes, Your Honor, yes. One further point, I would mention, if I can, another case that references this type of issue. It's really there are sort of two lines, long line of cases that interprets the statute and the other case law the way Father's proposing here. But another case that arguably does it a different way is adoption of Malik, M-A-L-I-K. That's 84 Mass Appellate Court 436. That's a 2013 case at pages 439 to 440. I would refer the court. So it made a similar error. That case was about a parent attempting to stipulate to a current parental unfitness and then reserve a right to appear at a, quote, best interest hearing in the future where we'll talk about competing plans. And the trial court approved the plan before we had a termination of parental rights decree. And Malik, sort of informally blesses that arrangement. But I would point out that the Supreme Judicial Court, in adoption of COWAN, that's 470 Mass 1013, 2014 COWAN, Q-U-A-N, that's really the only SJC case to comment on the issue. And in footnote 2, it expressed no view on the correctness of this court's interpretations in Malik and Varik. And this court has an opportunity to fix that issue. And Father would ask you to do so.
All right, thank you, counsel. I think we have to leave it there. And now we're going to hear from the department via Attorney Walsh.
Yes, good morning. May it please the court. Chris Walsh here representing the Department of Children and Families. Justice Englander, to your question about the policy reason why Varik, or I may slip into call it Varick, that's how I'm pronouncing it to this point. The policy reason why Varick was properly decided has to do with stability for the child. The idea for the best interests analysis is that the parent has already been determined to be unfit to a near for the indefinite future. And then the second prong is what is the best interest of the child to terminate parental rights. The best interest has to consider the plan, as the statute says, and as you pointed out, but that is not in and of itself a prerequisite. It's about the best interests of the child. And if the trial court finds that the best interest of the child is the termination of parental rights, then that stands on its own. And I believe it's adoption of Nancy, the Supreme Judicial Court case in 2004, talks about this idea of stability for the child. Once the unfitness determination has been made about the parent, trying to have that parent then be able to continuously relitigate this notion of what the plan should be and what's in the best interest simply does not match up from a policy perspective.
Well, maybe what if it's not continuously, but what if it's while the appeal is pending from the decree and the basis of the appeal is the challenge to the plan, the parent who's being terminated retains his or her right to be heard on any other plan or implementation of a plan that the court is considering until such time as the appeal is resolved. That doesn't seem to me to create any long-term stability, because as long as it's on appeal, you've got that uncertainty there.
Justice Sachs, a couple points in response to that. Number one, the fact that father was not a part of the 29B hearing is simply a creature of statute in the way that the statute was written by the legislature. Once the decree terminating parental rights has been entered, even if the case is up on appeal, those 29B hearings have to continue on an annual basis. And the parent no longer is a party to those appeals because the decree has been entered.
What particular language says that the father who's been terminated cannot participate in the 29B hearing?
I believe it's, I don't have the statute pulled up in front of me right now, but I believe that once the decree terminating parental rights has been entered, that therefore bars that parent from continuing to be a part of those permanency hearings. And I believe it is in 29B. I can find specific.
What language. Chapter?
Chapter 119, section 29B, Your Honor. But this is different. I would actually say something opposite of Attorney Cohen. If this case were remanded, I agree that the father would actually have standing in a further hearing to challenge the department's plan at that particular point in time, because a remand is a continuation of these same proceedings. The 29B hearings that have to happen on a regular basis are on a parallel track. They're separate, and the father doesn't have a right to participate. It's not a matter of standing in those 29B hearings, but it would be a matter of standing.
Let me understand 29B a little bit better. 29B is what happened in 2020, right?
Correct.
And the issue on in that 29B was going to be whether this other adoptive resource should be approved by the court?
Yes, the 29B hearing is an interim permanency hearing considering the best interests of the child and whether that particular plan, that adoptive resource, would be in the child's best interests. And that is what happened in August of 2020.
And was a decree entered at that time?
I believe it was, Your Honor.
Was it appealed?
I was not counsel at that stage, so I am unfamiliar. If that was
what you say, by the way, sounds a bit to me like an Ipsy Dixit. You say because so I assume in a 29B, any lawful parents would have notice and the opportunity to be heard.
Yes, that is correct.
You
But
say,
once,
well, because the parent's rights had been terminated as of August of 2020, he didn't have either notice or an opportunity to be heard.
That's right, Your Honor.
Which I say, of course, the termination was then currently subject to appeal. So the real question is, does that matter? And that's, I think, why Justice Sachs was asking you, what's the exact language of 29B as to who has the rights to be present?
Yes, I apologize. I don't have the statutory language in front of me, but I think to the point about mootness and whether any of this matters at the end of the day, the standard that is applied at a 29B hearing would be the same standard that would be applied on remand, and that's the best interests of the child. The trial court here found this adoptive resource that's in Tennessee to be in the best interests of the child, and remanding here would be asking the trial court to conduct the same exact analysis all over again. That's already happened a few months ago over this course of this summer, and there would be no difference whether or not that goes down on remand at this point or it happened at the 29B hearing. Father had the chance to challenge this adoptive resource in Tennessee. This person was identified by name in the department's amended plan.
But at that point, it was kind of a pipe dream, wasn't it?
Well, Your Honor, I
wasn't much information available about her.
I'd respectfully disagree, Justice Sachs, because Record Appendix 308, the department's amended plan in June 2019, specifically lists this individual by name. It explains the history that had led up to that particular point in time.
Okay, but no real details about whether that person is, adoption by that person would really be in the best interest of the child. It's just a family resource that needs to be evaluated under the ICPC.
Correct, that's right. And
that's about all that was available.
That's correct.
Okay. Can I just ask you, can you please be sure, I've looked at 29B, I don't see the language prohibiting participation by a parent whose right has been terminated. So you don't need to do it now, but can you please let us know where that language is, whether it's in some other statute? And also, what is it that would support your position that if we remanded this, the father could participate?
Yes, I will follow up with that information.
Yeah, I'm not following your position, counsel, because basically you're saying that he has a right to participate after Varique when his rights are definitely terminated, but he doesn't have a right to participate in the 29B when whether his rights have been terminated is still up for consideration. That doesn't make any logical sense.
I agree that it's not necessarily the clearest, but I think it's the creature of how the statutes are written. Here, if the case was remanded, if the court were inclined to do so on the consideration of the adoption plan, then it would be a continuation of the same proceedings, and father would have standing as part of the continuation of proceedings.
Even though his rights have been terminated.
Even though his rights have been terminated, that's correct.
Do you think that was the same in Varique, even though Varique didn't say so?
I believe so, Justice Sachs, yes.
So you understand you're making a better argument than for the father, because you're telling us that it matters then, that the remand would not be empty because the father would be able to participate and he would then have a chance to attack or challenge or put, an independent set of eyes on the department to determine whether what happened really was in the best interest of the child.
I understand that I'm actually supporting father's position in some regards, Your Honor, but I would still maintain that the
You're telling me that the department would not file a motion to exclude the father at that point when it goes back on the grounds that his parental rights have been terminated and he has no standing?
If it's a continuation of the same proceeding, Justice Englander, I believe the department would take the position that he has standing. It's part of the same proceeding, and that's separate and apart from a permanency hearing, which is.
I understand the words you're saying, but I don't understand the rationale. But okay.
But remand at this point would not be an empty gesture. It would give the father an opportunity to participate.
Yeah, the department's position is that it would give father an opportunity to participate, but it's nonetheless moot anyways, because father had the chance to challenge this adoptive resource in Tennessee back in 2019. The amended plan named this person specifically. Father could have called that person as a witness, father did submit a motion to strike portions of the department's amended plan, did nothing with respect to this other adoptive resource, and had the chance to litigate it at that particular point in time, didn't do so. So I'm happy to answer any further questions, but I see my time has run up.
Does the panel have any questions for Attorney Walsh? Okay, then we'll go to the child's counsel, Attorney Russell.
Good morning, Attorney Russell. May it please the court. Attorney Russell here on behalf of the child. First, I want to address and distinguish this case from Varick with respect to the sufficiency of the adoption plan. I would submit that in Varick, the child there was actually placed in a comprehensive, intensive foster care. I think that is important with regard to my client here in this case. She did have some ongoing issues, the lying, the urenesis, but she is now and has always been in a standard foster home. She's doing well. She's thriving by all accounts, by all testimony. The court found that she is thriving academically. She's doing well. Socially, she's doing well. Therefore, the department's plan was sufficient in that regard, did not have to.
So, counsel, though, shouldn't we at least require the department to say this child just needs a standard foster parent home? Or, I mean, because right now what we seem to have is silence from the department. I mean, they can't, I mean, it's not be a big lift for them to say the child does not have, need a specialized placement.
I think the lack of facts set forth in the adoption plan suggests the same, if not stated outwardly or expressly. They addressed all of her needs. They addressed how the continuing needs were being already addressed by professionals. I don't think it overtly or expressly need to state she does
but
not.
How do we know then that they're not, I mean, how does a judge check that they're doing what they're supposed to be doing unless we actually have them say the child does not need a specialized placement or the child does need a specialized placement?
Well, in these 29B hearings yearly, when the court is checking in and ensuring that the child is receiving all the services that she may require. I think that based on the testimony at trial, based on the record, based on the department's plan, everything that was laid out that this child needs was sufficiently stated. Therefore, I don't think, again, I just don't think it was necessary to outwardly say she does not need a specialized foster care under these circumstances.
Do you think that would have been enough, counsel? Sorry, go ahead, Justice. Go ahead, Justice.
You've heard defense counsel, you've heard the father's counsel say that I've lost my train of thought. You've heard the father's counsel say that the child was seeing a trauma-informed counselor, and that's an indication the child needed a trauma-informed placement. What do you say to that?
I would say that, again, if that was what was necessary, she would have already been placed in a more intensive foster placement right now, or she would have been over this whole period of time. It would be clear if she was, dysregulated by now because of where she was placed. If she needed more intensive, constant, specialized care, we would know that by now. It's been, at the time of trial, it was well over a year, maybe a year and a half since she was placed in DCF's custody, and there was no indication that she needed a higher level of care than what she was already receiving at this standard foster home with other children living there with her, going to school regularly. She was in a regular elementary school. There was no suggestion that she needed anything specialized, even if she did require ongoing counseling to deal with actions of father or whatever may have triggered this trauma in her. And just to get back to whether or not a remand would be moot at this point, I would have to diverge from DCF's position that father would have standing on remand. In footnote 13 of the Varick decision, when they make the decision that father's terminated rights can stand, that they do not need to be vacated, they do acknowledge that even if the department's plan was sufficient at trial and there was enough information there, DCF is not held to that adoption plan ongoing. These cases, they change, they evolve over time. The child's needs may change over time. So the DCF's adoption plan may change over time with the needs of the child. And if all is done and if the plan was sufficient, so there's no appeal here because the plan is found to be sufficient, father or mother or whomever would not have standing at these ongoing yearly permanency plans. So if father's rights are terminated now, there's no reason for him to participate even on remand, because otherwise he wouldn't have been participating even if the plan was sufficient to begin with.
So you think that remand here would be an unnecessary and really empty gesture because the father would not have the right to participate?
Yes, Judge, that's correct. And I don't know if you have any other further questions.
Let me follow that through if I could, because that's helpful. So if we were to believe that Varick can be followed to the extent that we affirm the termination of the father's rights separately from a determination with respect to the adequacy of the plan, then the father also had no standing for the 29B. There was no prejudice to the father from not being present for that. That has now been decided, and there's no reason to send it back because the father no longer has standing in any capacity.
That's correct, particularly here where father has had the opportunity to oppose and attack DCF's plan. The plan has not substantially changed from the plan they set forth at the time of trial. As Attorney Walsh already pointed out, the ICPC was identified at trial.
The plan that they presented in 2020 wasn't at all fleshed out at the time of trial.
It was not fleshed out, but the placement was identified at that point. And father could have argued and crossed the workers at the time of trial, and he chose not to.
I take it you think that what a parent should do in this circumstances was presented here is that should have tried to delay a decision on termination to allow the facts on the ground to develop more fully so that there was a richer picture for everybody, including the parent.
Yes, if father felt that there should have been more information about this maternal cousin, he could have moved for that exactly, Your Honor, which did not occur in this particular circumstance.
All right, your time has expired. Do I see any questions? Seeing none. Excellent. Good afternoon. This is a continuation of the November 13th, 2020 sitting of the Appeals Court. We are now calling case number 2020-E-0076, Lisa Dolan versus Shaun Dolan. Each side has 15 minutes. And I assure you, we have read your materials, so I'd encourage you to jump to the heart of your matter. I will tell you in particular, I know that I have a number of questions. So we will hear from Mr. Dolan arguing on behalf of Mr. Dolan first.
Good afternoon. Again, Sandy Dolan on behalf of the appellant, Shaun Dolan. As the panel is aware, this appeal centers on the application of components of the Alimony Reform Act to findings made by the modification judge in her judgment, findings which were largely entirely unchallenged, I dare say, and supported by the evidence. For context, I think let me briefly just reiterate what happened in the divorce in 2016 when the divorce judge applied the Alimony Reform Act, specifically Section 53, to the alimony calculus, and using earned income levels, applied the delta called for under section 53 and ordered alimony based on 1/3 of the delta between the two incomes. The parties also received a.
She says alimony to be paid as unallocated support.
Correct.
And your sister makes quite a bit of that and says that because it's unallocated support, the 53C1 limitation on considering income from assets divided under section 34 doesn't apply. Can you address that, how it's characterized?
I don't believe there's a material difference between an unallocated support order and a so-called traditional alimony support order. The parties agreed here to use the unallocated characterization, which is as deductible and includable as alimony under the Internal Revenue Code.
Is that in both parties' interests?
Well, it is certainly in both parties' interests for two reasons. One, it provides a greater income stream or a greater payment stream of support. And you'll note that in the judgment, the modification judgment did a calculation of the guidelines alone and came up with a number which is a good $900 or so less per week than the amount ordered under the modification judgment. So that additional payment better addresses the mother's needs, if you will, while also providing the second benefit, which is to my client.
Did the characterization alone produce the higher amount?
It does, because at the time, well, if you look at the Alimony Reform Act talks about a 30 to 35% delta between the incomes. And that's what was used at the divorce, 33% of the difference. The application of the guidelines in and of themselves would produce a lower percentage and a lower amount. And as the judge pointed out, and I believe in a footnote, it was a good $900 less.
Okay, but what if the judge had just said, this is alimony?
I don't think there's a material difference.
Okay, so
even the guidelines allow a trial judge to recharacterize child support as unallocated alimony to allow for that greater payment stream to the recipient.
But we know that, first of all, actually, you never told us the second benefit because we keep interrupting you. So could we just get that out from you?
The second benefit would be the deductibility to my client of a greater number or greater amount paid each week. Because child support is non-deductible.
Okay.
And does that allow him to pay more? Or does that usually result in a greater payment because it's going to be deductible to him, or he's considered to have more resources from which to pay because it will be deductible?
Well, the benefit is that it creates the greater payment stream. And the trade-off for that is the deductibility. This judgment in 2016 was before the revocation of the deductibility under the Trump tax reform. So the benefit continues on, at least we assume it continues on, to a greater benefit to both parties, both mom and dad here.
Counsel, help me with this basic question, if I could. Could there be child support on top of the alimony?
Well, there could be, provided you didn't double count the income. So if all of the income was used in calculating, you can't do both. And here, and this is sort of the crux of the issue, Your Honor. Here, my client's earned income level went from 480,000 at the divorce to 300,000 at the modification. Now that's earned income. The judge found that the additional income she characterized as just income, gross income, included the stream of payments that he received upon the sale of his business. And the difference is significant. There's a $9,000 plus per week payment that he's receiving as a result of the sale of his business, which was found to be a legitimate sale, not done for any untoward reason.
And the timing in that is, so he stops receiving that as of September 1st, 2000 or August 1st, 2017, right? But when did he start receiving it? When was the sale of the business? Remind me.
It was a 2-year period.
Okay.
So it was from 17 to 19 were the payments in various components. One was a significant lump sum upon the close of the sale. There was a monthly payment for 24 months, and then there was a lump sum payment on the first anniversary. So it's
counsel, on this unallocated part, some of it was child support because child support is not waivable in Massachusetts, right? And the children were under 18 at the time of the divorce. And even when they were over 18, they were still unemancipated, right?
Correct. But I don't think the characterization of unallocated versus alimony is, I suggest it's an immaterial characterization. If you want to look at it one way, you could say that the unallocated payment does recognize that there is a component related to the children, okay? If it was just alimony, and in this case, the children went from high school to college, and that was one of the considerations the judge used in her decision-making. And the additional component of payments can be a consideration that might influence a modification of an unallocated payment, but it's not a requirement. It's really just a nomenclature that parties use in some respects.
Well, but no, there's a material difference between them, which is the key, which is 53C says if it's alimony, you can't consider income from a divided asset, but if it's child support, you can, right?
Yes, but remember.
So when you say there's no difference between them, I'm struggling with that for the same reason I think that Justice Henry was asking your question. The question.
There's no difference there's no practical difference because they're both treated the same in terms of both the increased income stream and the deductibility. Again, if Judge Gorman here just ran the guidelines and just ran it as child support, the payment would be $700 or so per week. Yet she ordered $1,680 per week on a modified basis. That additional $900 is the benefit to the mother, and the deductibility is the benefit to the father. So there's no material difference. And they're both calculated under a 33% difference in incomes.
Does there be a cap on the child support?
No, there's only
max out. So who cares that in calculating child support, you can consider the other income because it would max out?
Well, child support can, right? Well, sorry. Child support can max out if you just apply the guidelines and don't go beyond the presumptive $250,000 combined threshold. But in this case, the judge
300 though, at 300, it's going to max out lower than 1680 is the point.
Yes.
And so
yes,
who cares?
That's my point. Yeah. And that's what the judge. And again, the parties agreed to this, and they did it intentionally. So I understand that the term is. I'm sorry.
First of all, which standard applies for modification? Is it section 49 or is it section 28? Because they are actually different standards.
In this case, I think it's section 49 and 53A. I think both apply. Not 28.
Even though an unallocated award includes both alimony and child support.
I do, yes, because you're getting that benefit of the tax. And I don't think that I guess I don't want to reiterate my argument endlessly.
Okay, but so we're clear though, section 53C1 does not apply to child support, right?
Yes, correct. I agree with that.
Okay.
Okay.
Does 53C1 decide, does it, let me ask the question slightly differently. So the court doesn't have, the law is clear, the court does not have to modify just because your client lost a third of his income, right?
Well, yeah, I think any modification is discretionary. It's not mandatory.
One way to look at this, and I'd like you to address this. One way to look at this is the judge decided not to modify until August 1st of 2019. Now, correct. Why isn't that within the judge's discretion in this case?
Okay.
And what is it about 53C that says anything about the decision not to modify until August 1st, 2019?
Because here the judge specifically found that my client was able to, during the litigation and then prospectively for another 5 months, he was able to meet the original alimony order using the asset stream that he got from the sale of his assets, period. Because his earned income went from 480 to 300, but his general stream of income coming in was higher, and the judge found that allowed him to meet his obligations. That's mixing the asset division with the support under
No, you have an
53C1.
assumption buried in that analysis, and the assumption is that the judge was somehow obligated to modify earlier than August 1st of 2019 because he couldn't meet his obligation with income. Right?
Well, he certainly couldn't meet his obligations based solely on his income that he received once his business sale sold, because that was roughly 100% of his income from his the 300,000. That's essentially what he was paying in support.
Yeah, but counsel, this is where I'm lost, because his half of the business was valued in the $800,000 range at the time of the divorce. And then you tell us that, you know, this was a failing business, had all kinds of problems, but yet somehow just a couple of years after the valuation in the divorce, the business is somehow miraculously worth 2.5 times what it was worth at the time of the modification. Okay. And in fact, the father negotiated the structure of the deal, and wife argues that basically he could have taken more money as a salary compensation. This was always an asset that both had value as an asset and as an income stream. He chose to take the upfront payment, but he could have spread that out, and his income could have been found to be more here. So I don't understand, where he had total control over the structure of this deal, I don't quite understand why we just take your word for it or his word for it that this was the value of the asset as opposed to the value of the income stream.
I don't think you have to take my word for it. I think that's what the judge found, and based on the evidence at trial. And certainly mother took the position that, you know, in some respects that this was an engineered result on behalf of my client. The judge simply didn't find that. You know, there were economic forces that caused the sale of this business. They were counted in the findings, and it led to the sale. And value,
I thought that the assets were divided equally. Why didn't the wife get these same payouts when the business was sold?
Because he received the business himself at 100%, and she received offsets in the divorce of equal value. And that's why I think that, you know, that income stream from the sale is both important for purposes of 53C1 and whether this is a double dip, a post-divorce double dip.
So
Okay,
since you mentioned double dip,
So, go ahead.
Yes.
Is your double dipping argument different in substance from your 53C1 argument? They both seem to say you can't consider income from an asset that was part of the property division.
I think there's overlap, Your Honor. I do think there are sort of shades of the same argument in both instances. I do think the Ludwig Lammeli case is worth considering, because I do think in that case they talk about, you know, an asset division where someone got an equitable interest in an asset, and if that's the case, that shouldn't be considered down the road for purposes of support, and that's precisely what happened here.
One other question: if we agree with you that it was error to consider the payments from the asset sales into determining the husband's income, you don't argue that it was an abuse of discretion for the judge to consider that the wife's needs would not decrease until August of 2019 because she was still paying college expenses until then. So even if we agreed on the calculation of the income, would we need to remand for the judge to back that income out of the calculation, but still consider that the wife had greater needs until August 1st of 2019, and therefore there may have been some reason to delay at least some part of the modification until then?
I don't think the judge was clear as to the date. I know my time is out. I know that the date that support ended did coincide with the cessation of the monthly payments under the sale. But I do think that, generally speaking, there was a consideration of my client's asset base and the income stream that was produced, with no consideration whatsoever of mom's assets that she received in the division. That dichotomy is simply unfair, and maybe an abuse of discretion.
Question: how is it, if he received essentially $2.7 million for the sale of his business, that he only had $2.6 million in assets? as of the time of the modification proceeding?
Well, he hadn't received all the payments at the time
He'd
of
received
the,
the vast bulk of them, over $2 million, right?
yes.
And he'd also had 2 houses that he'd sold and gotten proceeds from. I'm having trouble understanding the numbers. They don't make any sense to me.
Well, certainly there was no finding that he dissipated assets or that his net worth per se, as reflected on his financial statement and as found by the judge, was not, lacked veracity.
Did the judge make a
It doesn't
finding?
I share his concern. It doesn't make sense.
Well, he did testify that he used assets to meet his obligations since the sale of the property. And that certainly impacted his net worth.
This is millions of dollars that seems to have disappeared. This doesn't make any sense.
Well, I don't think it's millions of dollars. He certainly testified to spending lavishly on certain things in his lifestyle. This case was not tried on a lifestyle dichotomy. And my client didn't seek relief on the basis of not being able to meet his own expenses. It was simply the use of his assets in the manner that I've suggested.
So just then to close this out, I guess, in chapter 53C1, I take it you're saying that this stream of income, what are you calling that? What does it fall under your view, under 53C?
Well, it's 2 things. It's the capital gain that he got from the sale of his business, and that's the asset that he retained. That's excluded under 53C1. Also, Chapter 53 makes reference to the definition of income under the guidelines, and I dare say that that would not include a payment of principal for the to a client in an alimony calculation, not a child support calculation. I see the difference there, but it would not include both the 1099 income that he gets as a result of his sale of his business and the principal payments he gets through the sale of that business. Again, you're mixing assets as apples with oranges as income, and that's not fair to my client. I get that there's a sticker shock component here. My client has a lot of money, to be sure, but so does mom, and mom's financial circumstances were not considered.
Sorry, counsel, it's not sticker shock. I mean, if your client chooses to take what is an income stream and reduce it to a capital asset, I'm not sure that he loses that it's right or unfair that you don't consider what that capital asset can throw off.
But you wouldn't, Your Honor, you wouldn't include the equity value of that business had he not sold it in this calculation. And you have to contrast it with no consideration was made of the wife's net worth in the calculation. But this is part of his net worth. This is his asset. It's just been converted from illiquid to liquid.
An income stream in part to an asset that you now say is off base, that's out of reach. Can I ask you one question? You said to me the judge found his net worth was 2.6 million. I do not find that finding. Can you tell me where it is?
Your Honor, I may have. I don't know if she made a specific finding as to their net worth. I don't want to misspeak. It certainly was. That was his net worth as reflected on his financial statement.
Received 1.5 million in net proceeds from the sale of real estate, and on top of that, he got 2-point-something million in assets from the sale of his business. That adds up to 4.2 million, which is a lot more than 2.6. I'm struggling with the numbers.
On which he paid capital gains upon the sale of both. The sales of the
taxes. I understand that. Yeah.
And at his rate, and his income tax rate is clearly upwards of 40% in some respects.
Okay, thank you.
All right, we'll hear from the Counsel Attorney Altman.
May it please the court, my name is Miriam Altman, and I'm arguing on behalf of the appellee Lisa Dolan. The trial court did not abuse its discretion in ruling that unallocated support would not be modified until August 2019 under Mass General Laws Chapter 49E, which provides for modification of alimony upon a material change in circumstances. The trial court in its rationale correctly cited the law as follows. 1, while the Alimony Reform Act created guidelines to aid judges in fashioning alimony orders, it did not alter the fundamental principle that the central issue relevant to alimony is the dependent spouse's need for support in relationship to the respective financial circumstances of the parties.
So first, I want to just confirm you do not contest that there was sufficient change in circumstances to modify the unallocated payment?
As of August 2019, that is correct, Your Honor. That is correct.
So what you're really saying is that originally in the divorce judgment, the judge found both parties were going to have a lower lifestyle than had they stayed married or when they were married. But that what's happening right now is that the wife's needs continue and have not been diminished. Is that correct?
That is correct, Your Honor. And the law as cited by the trial judge is that capital assets can be used to evaluate a spouse's ability to pay alimony in a modification proceeding, and that a decrease in the support provider's income does not alone compel modification because
capital assets that were included in the property division can be considered.
That is correct. The case of Katz versus Katz.
That was that Katz was decided before the Alimony Reform Act and 53C1. Does that survive?
I would say that it does under the
How
Hassey
can it
case.
survive? The language is clear. When issuing an order for alimony, the court shall exclude from its income calculation capital gains income, dividend and interest income which derive from assets equitably divided.
That's because there are two different statutes at play here. The first statute is 49E, which provides that a payor or payee can seek a modification of alimony upon a material change of circumstances.
Okay, but
that
it's
is
alimony.
That is I'm sorry, Your Honor.
It's still alimony. It still fits under the term alimony in 53C.
Correct.
When issuing an order for alimony, right?
Correct, but it's a two-step process. The first step is to determine whether there has been a material change of circumstances under 49E. If there has not been, you never reach the next statute, which is Chapter 53.
And are you saying that the judge...
Go ahead.
Are you saying that the judge found that there was no material change of circumstances until August 1st, 2019?
That is what I'm saying, Your Honor, because what the
I don't
judge...
see that very clearly. She says that's when the modification should be effective, but she doesn't say that that's... I mean, why wasn't the change of circumstances when the father had to sell his business? And sure, he got an sale of asset stream, but his earned income decreased to $300,000 effective, I think, August 1st of 2017, 2 years earlier.
Because under 49E, the fact that a payor's income goes down is not dispositive of the issue as to whether there's been a material change in circumstances.
Right, but that's different than what you're saying. Okay. Those principles are all, I think we're all agreed on that principle. But you're saying the judge found no basis to modify until August 1, 2019. That's not what she said. She said, unquestionably, there have been several material changes of circumstances since the parties were divorced. And she goes on to list those. Many of those things that she lists occurred prior to October 1st, 2019.
Well, two of them didn't. The first thing that didn't change was the wife's needs. The trial court found that the mother's income was $600 weekly and that her expenses were $4,444 weekly until August 2019.
Yeah. And then it was going to decrease by $353 a week or something. I mean, that's clearly not the major driving force behind the circumstances.
That was certainly one of the forces behind it.
But not the most significant one.
And then, well, we would argue that the mother's needs are the most significant issue here. But the second was that the father's income at that time would decrease because as of August, he was going to receive $2.5 million over a 2-year time period between August 1st, 2017 through August 1st, 2019 from the sale of his business, some of which was capital gain income. Our argument is that under Section 49E, the $2.5 million in proceeds from the sale of the business was relevant and material to his ability to pay, which goes to the issue of whether there has been a material change in circumstances. Our argument is that 53C1 does not apply to the inquiry under 49E as to whether there's been material change in circumstances. 49E and 53 are two separate statutory schemes and create a two-step process. The first step is that the court must determine under 49E whether there has been a material change in circumstances, considering the mother's needs and the father's ability without limitation to
Okay,
pay
so I
support.
just want to make sure I understand you. So you're basically saying that until August 1st, 2019, there was no material change under 49E. And so we affirm on that basis. And then the question is, going forward from there, you agree there was a material change?
We do. And what the statutes...
But I'm right about both parts of that?
You are correct. And in the event that the court finds the material change under 49E, which it did here, effective August 1st, 2019, then the second...
In the record that the judge has made this distinction. I get that she changed the payments as of August 1st, but where does she say that's when the material changes?
Well, she says that she says in her rationale page, I think it's 59 of my brief, I'm not sure what this is from, but page 17 of her decision, that she would have a continued need for support and that her weekly expenses would not decrease from $4,440 a week until $4,000 a week until the older child's college ended. And you have to be careful here because under the tax laws, you can't say upon emancipation of the child, because then the IRS could go back and recharacterize everything as not being deductible. So she said until the mother stopped paying for the daughter's I'm sorry, I'm maybe reading more into this, but I just, maybe that's not what the judge meant. But in any event, it was not until August, maybe the daughter graduated in May, but it was not until August after her emancipation when she would have to stop paying for those housing expenses. And then the court
I
also...
understand that you represent the mother or the wife and that your focus is on the wife's needs, but I agree with Judge Sachs that this decision has very little to do with the wife's needs and very much to do with the father's ability to pay. And so, you know, the focus on that, it seems to me, is not consistent actually even with what the judge wrote.
Well, the judge also said on page 17 of her decision that the court finds that in light of the above, which was his income plus other income coming in, he had the ability to continue to pay his current alimony obligation through July 2019. And then when you read her judgment, the judgment goes into effect as of July 2019, based on these two events as to need and ability to pay. So as I was arguing, the second step after you make the determination under 49E, looking at need and ability to pay, and again, income is only one component of that. After that, you move into 53, section 53 of the statute. And here, the court found that under 49E, that the change would occur as of August 2019. And at that point, it did apply. And at that point, when you see the calculation, it does not include any capital gain income whatsoever in accordance with 53C1. And Justice Englander, I just wanted to say that previously at the beginning of Attorney DOLAN's argument, you were asking about the child support calculation. And I would just say that if it were not going to be continued as unallocated support, this is a hypothetical, but as a child support order, we wouldn't be looking at the full $15,000, including the capital gain income, and not be running it on just his $300,000, because our argument
At the end of July of 2019, you would look at the full 15,000.
Well, before starting July, starting when he filed in September of 2017, we would be arguing if it was going to be a child support, you'd look at the full.
And I understand that point. But under the guidelines, you wouldn't be entitled to anything over and above the whatever I think it's 250,000. After that, it becomes discretionary, correct?
You're absolutely correct. But in running the guidelines and in arguing what the discretionary additional amount might be or should be, we would run it on that higher number. I just wanted to let you know that because you've been talking about the lower number.
So
but,
the divorce judgment said that this is alimony to be paid as unallocated support. but that sections 48 through 55 will apply in their entirety, with an exception that's not relevant here. And the judge, both the amended divorce judgment and the modification judgment, repeatedly refer to this award as being alimony payable as unallocated support. So why doesn't 53C1 apply? Because 53C1 speaks about alimony and what income.
So as I argued previously, because the first step is under 49E to see whether there's a material change of circumstances.
And you think the judge determined that there was no material change of circumstances until August 1st of 2019?
Absolutely, Your Honor.
What is it that allows the judge to consider the asset stream that the husband, sorry, not the asset stream, the sale of asset income that the husband was getting from August 1st of 17 through August 1st of 19, and decide that even though his earned income has decreased, he's getting that sale of asset stream, so there's been no change in circumstances. I don't see anything explicitly in 49E that governs that. So,
well, there's nothing in 49E either that says that material change in circumstances, but by the way, don't include another part of this chapter, another section, 53, don't include any of that C1 income. The legislature could have written that, but they didn't. So the same argument applies, I think, to the 53B argument. 53B is that cap on the differences between the parties' incomes between 30 and 35% of their respective incomes. And it's the same argument with regard to that. Section 49E provides for the modification of alimony upon a material change in circumstances, and it does not state that there will be an automatic modification of alimony in the event the amount exceeds 35% of the difference in the parties' incomes following the date of divorce. If income were the only factor, again, the legislature could have written Section 49E that way, but they did not. So again, it is a two-step process, and that is what the court did here and why that there was no abuse of discretion. I wanted to just very briefly address the father's new argument raised for the first time on appeal as to the alleged double dip. And again, the same argument applies here. Under 49E, in determining the material change, the court considered many factors, including but not limited to the sales proceeds the father would receive through August 2019, and the fact that the mother's needs would not decrease until 2019. And it was in the court's discretion as to whether to make the order retroactive. The law is clear on that. It's not mandatory. And here, where her findings are clear that she did see the material change in circumstances occurring until August 2019, there was no error in not making it retroactive. In finding that there was a material change in circumstances under 49E, the trial court stated it in its rationale. After consideration of all relevant factors under 53A, the needs of the children for their own support, the mother's need for support, and the father's ability to pay support, including the totality of the father's circumstances, the court has entered an unallocated support order of $1,680 per week commencing on August 1st, 2019. The reduced amount of unallocated support was not based on any capital gain income, and it represents 32.5% of the difference between the parties' respective incomes as of August 2019, which complies with 53B and 53C1. The court therefore correctly applied Section 49E, 53A, 53B, and 53C, and there was no abuse of discretion. Thank you.
Did you challenge his financials where he said he had $2.6 million in assets, given all the lump sum payments that had been made?
I was not trial counsel, Your Honor, so it wasn't me personally, but going over the record, there was quite a bit of evidence about the father's expenditures, like $79,000 buying jewelry for his wife, a $12,000 wedding, $200,000 of expenses to renovate his 4-bedroom, 5-bathroom home, which went to show that he was, that he was able to maintain the marital lifestyle, and he did have the ability to pay. Thank you.
Any other questions? Anyone? All right. Thank you very much. We're not live yet.
Okay, we are live and on the record.
Excellent. I am calling our last case today, November 13th, 2020, and that is 2019-P-0977, John Doe number 523288 versus Sex Offender Registry Board. And we are going to hear first from Attorney Burkholder.
May it please the court, Attorney Fred Burkholder for Doe number 523288. My brief is fairly comprehensive. As a result, I don't want to belabor a lot of the points. I did present to the court yesterday a 16L letter with regards to a case which I discovered during my preparation that entitled Doe 524454. I'm hoping that it was circulated to justices because it's important. I can assure you
we have it already.
All right, I thought that you did. That case is important to my argument for the following. The facts in that case were not unlike where we are in this case. We have an expert. That expert came forth and gave an opinion that there was a low risk. That opinion was then rejected by the court, and then the Court of Appeals had to determine whether or not there was an adequate objective reason to do so. And in the analysis, several factors that were relevant in my case were relevant in that case. And it also involved a juvenile, an individual who was a juvenile at the time of his first offense, and then subsequently offended as an adult. So the facts parallel to a great degree, and I think they're instructive. So what do we have here? We have a situation with regards to my favorite issue, repetitive and compulsive behavior, because in that decision for the first time, it actually says specifically, the hearing examiner concluded that Doe's behavior was repetitive, but made no finding whether his behavior was compulsive. Now, the question may become, why did that argument get presented in my original brief? Well, that's because Judge Milkey in 22188 wrote a concurring opinion, and I just argued 2 weeks ago on 3 other cases before him and 2 other panel members that it should go further, but that never came out. But this decision did come out, and somehow I didn't catch that language. That's why I brought it to your attention. So what do we have?
This opinion, counsel, but I don't understand. What are you saying with respect to this case, the facts of this case, that it's not repetitive or it's not compulsive?
It's not compulsive. Well, at least there's no evidence of it. And maybe I should say it this way.
There's no evidence of compulsive behavior on the part of your client, even though he appears to, over a period of years, go to libraries and address women that he doesn't know?
I don't know that that's sexual misconduct, Your Honor. I'm sorry. And I think Dr. Zeisel addressed that in his testimony.
Well, I understand the point that it may not be sexual, except in the one instance that is the index offense.
Right.
But you can't use this other behavior to shed light on whether his behavior is compulsive?
I think somebody needs to present evidence in that regard, and that certainly didn't come out in the testimony of Dr. Zeisel. And interestingly,
so that's an argument. Let me just make sure I understand. That's an argument that they needed expert testimony to show compulsion, because there's evidence that at age 22, he in a library sexually assaulted a woman, and there's a conviction as to that, right? Mm-hmm. And then there's also evidence that at that same age, on 2 other occasions, he approached women, 2 or 3 other occasions, he approached women in similar settings, not with sexual assaults, but with something that caused them to think that something going on was quite odd, right?
Well, the first thing I'm going to say with regards to that is I think Dr. Zeisel approached or addressed that, and I think some of his statements should be given some credence. And number one is there's a race issue. And secondly, there's a size issue with regards to these individuals. And thirdly, there is obviously the ongoing climate of concern. So you have a man who approaches someone. He didn't touch anybody. He didn't use any profane language. He didn't do anything other than potentially make them uncomfortable. Well, that's fine, but that's not illegal. So
what do you mean there's a race issue?
Well, I mean, Dr. Zeisel says in his testimony specifically, you have to look here. There's potentially, a race component to their annoyance. And
does the record show that they were of a different race?
I believe it does. Yes, I believe it does. And Dr. Zeisel picked up on that. And you know, to get back to Dr. Zeisel, with regards to what hearing examiner Cruz said, hearing examiner Cruz says when he rejects the opinion, he says, well, Dr. Zeisel didn't consider the 13-year-old indecent exposure. He certainly did. He certainly did, because he admits during his testimony he was aware of it, the exposure incident. He admits it had a sexual component, and that it even fell within the umbrella of sexual misconduct. So he knew about it, he considered it, and nonetheless, he disregarded it. Now, that gets back to my other favorite issue in these cases, and that is, we have a gentleman here. All right, I'll strike that term. We have an offender here that is.
Did Zeisel testify live, or do we just
Live.
have a report?
Live.
He testified live and he was cross-examined?
He was by Miss Greenaway. So what do we have here? We have an individual who is under factor 4. You have to be under age 13. This guy wasn't under age 13. He's 13. He gets involved in a peer aged situation with another individual, basically, quote unquote, the playing doctor routine if it's in a private setting. And that's used as a predicate offense to now apply a repetitive and compulsive behavior to an individual who's basically mentally ill. That's his problem. And that's what Dr. Zeisel says his problem is. And Dr. Zeisel says certainly when he doesn't control his medications, that he is a problem. But his medications are controlled. And that's my next problem with Mr. Cruz, or hearing examiner Cruz's analysis. He says there's no medical evidence that this man is on medication. He's basically disregarding Zeisel's evaluation.
Not counsel. Okay. It's fine to zealously advocate, and you're doing that. But he didn't say there's no evidence.
He certainly did. He certainly did. I'll read it to you.
He questioned. He said
No. He said it, because I couldn't believe it when I read it.
All right.
I couldn't believe it when I read it. It
So
said,
I misread this apparently. So why don't you correct me?
I'm going to find the actual language. It says, hang on one second. I did not find in the record any verification that the medication is administered to him by a medical facility. That's on page 14 of the decision, 134 of the second exhibit appendix. So basically, he just completely disregards the fact that Dr. Zeisel, who's very well respected in these circles, and testifies both on behalf of the Commonwealth as well as on behalf of
Can we slow down for a second? Counsel, slow down for a second. So what you just read to me is not what you said earlier. So he does say, I do not find any verification that medication is administered to him by a medical facility. Why is that wrong? Where in the record am I going to find something that contradicts that? Does Zeisel say that?
Zeisel says that there's a packed team which goes to his house on a tri-monthly basis, gets 4 shots, and he's injected with what's called IM, and that is a version of IM Virga, which is a intravenous method of providing medication to individuals with schizophrenics. It's much preferred. It's frankly sought after by many people who suffer from it because they fight their medications. And this guy previously was under a Rogers order.
Happens based on
please.
what? What is
Again, I didn't hear it.
What's the basis in the record for Zeisel's statement that this is being done regularly?
All the records that he reviewed. In his testimony, he indicates this is what I reviewed, and it included, I have a copy of his report right here. I think he lists the same things. And it includes Lowell General Hospital note, Lisa Brown, PM, NP 11/28/2016. So what happened, Your Honors, is he was admittedly having a really terrible time controlling his medication. He even presented at one point and wanted to be committed. He's had difficulty since the offenses occurred. Frank,
just to get the timeline right, my understanding is that occurred in late 15 and early 16 when he clearly was not on his meds. He came in and said, I need help, right?
That's correct.
So now you're saying 10 months later, Zeisel speaks to somebody who says he is on his meds and this is how he's on his meds. Is that what you're-
Basically, he started receiving the appropriate treatment from the PAC team, and that included the injections.
So counsel, I just want to make sure I'm following you. So just, you're saying the hearing examiner made a finding that the administration of his medication was not reliable because it was not at a facility, and that was or by a facility, and that was error because he is getting them reliably by having this team come to where he lives.
That's however you characterize what hearing examiner Cruz said, how you interpret this statement. However, I do not find in the record any verification the medication is administered to him by a medical facility. Is there a separate independent medical report? There is not. But is there Dr. Zeisel who there's a recent decision.
Well, who has the burden of proof on this? And where are you in his decision? Because I'm maybe there's something wrong with what I'm searching. That's why I'm
Page
looking
14 of the decision, which is
Thank you.
under transcript or exhibit file 2, page 134.
Yeah, okay.
All right.
Immediately before the heading additional factors, Judge Henry.
Perfectly, yes.
So was it beyond the discretion of the hearing examiner to say, look, I see Dr. Zeisel's testimony on medication, but given the history of his difficulty with medication, I'm not confident that he's going to continue as Dr. Zeisel is. And that is one of my bases for not following Dr. Zeisel's opinion about the low risk. Is that an abuse of discretion?
I think that it is. And I think this court spoke to it in a.
He had to believe, or he had to believe Dr.
Well,
Zeisel's opinion?
let me tell you what the court said. The court said I'll see if I can find it. In one of the more recent decisions from this court, I'll find it while we're talking. It basically said once there is an appointment of an expert and that expert then conducts an examination, they are deemed to be reliable unless their opinion is based upon hearsay, unreliable hearsay, or in that case I think it was the same case that I referred to.
Can't possibly be what our law said. It can't possibly be that just because they testified, they're deemed to be reliable unless.
There are
many, many cases that say that it's free. They're free to disregard anything that an expert says.
I found
they have
it.
to give a reason.
I found it. I'll read it to you. It says, this is word for word. It says, once a hearing examiner, this is from 2340076 at 484 Mass 666, page 673, 2020 decision. Once a hearing examiner determines the sex offender deserved expert funds, the expert's future testimony and admissions may be considered reliable so long as they are not based on rumor or unreliable hearsay. That's word for word.
Okay, that's for admissibility purposes, though. That doesn't mean that the hearing.
No, it's unreliable. I'm not. Well, you can characterize it as for admissibility. I'm characterizing it as reliability because that's the same standard that that SORB uses when they consider hearsay.
All right, okay, but was the hearing examiner required to accept Dr. Zeisel's testimony?
No, he was not. But
so why wasn't the history of your client's difficulty with being compliant with medication something that the hearing examiner could take into account and saying, Dr. Zeisel's confident he'll go on getting meds. I'm not so confident. Therefore, I don't agree with Dr. Zeisel's risk assessment.
I don't disagree that he can do that. My opinion is that it's not an objective, adequate reason. I don't think it's enough. And there's another case that says recently that said, and I'll find it here. It says that even if a hearing or even if an expert does, I found it right here. Even if an expert, there it says, that an expert's testimony spoke to some but not all the relevant considerations is not an objectively adequate reason to reject that testimony. And so I guess when
Sorry, Mr. Burkholder, I think you're frozen on us.
Yeah, we'll just, I've got my eye on the timer. He was coming in and out. Mr. Burkholder? Madam Clerk?
Yeah, start over. He's got like a minute and 10 seconds or so.
Madam Clerk?
Yeah, you're gonna have to get him to get out, reboot, basically.
In a minute and a half or so, and we may have more questions. So if you could go back and just go back where you were a couple minutes ago, that'd be great.
All right. Where I was that I think that what a objectively reasonable reason, explicit and objectively adequate reason for rejection of the opinion is something that is not clearly defined. I think it depends to some degree upon application of the proper application of the other factors. And I think here that hearing examiner Cruz did not properly apply factor 4 because my client was not under age 13 at which time the first offense occurred. So I don't think 4 was properly applied. And then I don't think that 2 was properly applied because I don't think there was any evidence of compulsiveness. So based upon those 3 things, now we have to look and say, was there enough remaining for rejection of the testimony? Then we have to start looking at the mitigating factors and see how they play in.
The
Interestingly,
point,
when you
though,
look
is saying
at
that what's wrong here is with your argument is that you're trying to argue that he was entitled to a juvenile framework because he had one offense as a teenager, but that really he's in an adult framework because he was 22 at the time of the governing offense. So what do you say to that?
do not disagree with that at all. And I know that's the argument Ms. Greenaway made and the like. My contention is that just like 15614 years ago said we have to look at age, I think we have to look at age here. I mean, we're trying to make a reasonable determination as to what to rely upon. And when you have a non-index offense that occurs between two not prepubescent, but at least school-age kids in a public setting, and there's no contact or otherwise, and it's quaffed on top of it, then all of a sudden to use that as a predicate is not enough. I want to say one more thing about mitigating factors, if I may.
Very briefly, because we are past the time.
All right. Let's talk about real briefly about mitigating factors. We already talked about Dr. Zeisel's opinion. Let's also talk about, I know Judge Engler's probably had enough of me already. There's no
that's
mention
not the case, counsel, but really you're past time. So I think you need to do it quickly.
All right.
You have 15 seconds. You got to wrap it up.
There's no mention of his activities outside of the house. The guy's adjusting, he's working, and he's driving, and he's doing the best that he can. He's got a tremendous amount of support. And there's no description whatsoever of any of that in the decision. Nobody considers it. Last thing.
Okay, we'll have to
Nobody
leave
talks
it there.
about dissemination at all.
We'll have to leave it there. We do have your brief. We understand your arguments. Thank you.
Thank you.
Now we'll hear from the board and Attorney Greenaway.
May it please the court. Roxanne Greenaway for the board. First, I actually wanted to draw the court's attention to this is the plaintiff's exhibit 2, where we have the transcript. And if you go to page 202, that begins the cross-examination with this idea that race was an issue in the discomfort these women were feeling. And I cross-examined Dr. Zeisel on that for a couple pages. And I asked him specifically, would you agree that basically the description of the behavior he was exhibiting would make many people uncomfortable regardless of the color of their skin? And he says, absolutely. And then on page 204, I asked him again, would you agree as we go through further descriptions of what Mr. Doe was doing, would you agree that that would make anyone uncomfortable regardless of the color of their skin? And he says, totally. So race was not an issue with regards to the inappropriate behavior that Mr. Doe was exhibiting outside of his sex offenses and his sexual misconduct.
But he's right that they were non-sexual, right?
Correct. He has
really, there are only 2 sexual offenses in the record, one of which is a 13-year-old on a 13-year-old non-contact 9 years before his next offense.
And that's not even a sex offense as defined.
Thank you. I was going to say that, Your Honor, there's one governing sex offense, which is the indecent assault and battery on the person over which he committed as an adult. And then he had sexual misconduct in his past when he was a juvenile, where he indecently exposed himself to a student.
Right, but the problem with it is, and I think your brother is right about this, that it's that 13 on 13 offense. It gives you all these elevating factors. It gives you repetitive and compulsive behavior. It gives you, I'm sorry, I'm gonna blank on the others, but there are 2 or 3 elevating factors that would not exist at all if you didn't consider the 13-year-old on 13-year-old behavior,
Age
right?
at time of first offense.
But you would be asking the hearing examiner to ignore salient facts in this case, which is, in fact, that the person before
Actually,
you.
I'm not asking him to ignore them. I'm asking him to consider them in light of what they are.
Well, he does. He does consider them. He indicates that this is.
He does. Go ahead.
Can you just can we hear your answer? I just want to hear what you have to say on this.
On which issue, sir? I'm sorry.
On whether to consider this behavior of a 13-year-old towards another 13-year-old.
Correct. Okay, so each person gets an individualized assessment. And in this individualized assessment, you have to look at all the facts in the case. And in this particular person's case, you have an incident that took place when he was a juvenile. His behavior since then, when you look at the disturbing behavior that occurs before he commits his sex offense, is that he's on a pattern where he's escalating his behavior towards adult women now. So you have someone who did have an incident in their past, which you cannot ignore, that over time is continuing to escalate and exhibit that behavior up until the fact where he then sexually assaults someone.
So, but just to put a fine point on this, so I think this is what Judge Englander might be getting at. I agree, we have this disturbing pattern of conduct after age 22, but if we either can't or cabin the use of the incident when he was age 13, you don't have several factors that are risk elevating factors, right?
You don't, but you also don't have the facts of this case, because the facts of this case, which when you look at the factors which the hearing examiners are mandated to follow, it indicates that if you have acts of sexual misconduct, you must consider those in factors 2 and 4, which are applicable.
What says he must consider them? I mean, or what is it? So yeah, he has to think about them. He has to consider them, but does he have to give them weight so that he says factor 2, repetitive and compulsive behavior applies. Factor 4, offender's age at first sex offense applies. Factor 22, diverse victim type. Factor 21, diverse victim. Factor 22, number of victims. All of those would go away. And where is it that he says, I've considered the fact that this occurred at age 13 and that this is not unusual behavior among 13-year-old children. And nevertheless, I've decided that it is sufficient and therefore ought to be considered. And all of these factors now come into play. Where is it in his opinion that he's thought about that?
There is nothing in the record that suggests that 13-year-olds, that this is normal behavior for 13-year-olds to indecently expose themselves to other students in school.
I didn't say it was lawful. I didn't
say lawful.
I'm sorry, counsel, let me finish. I would like it to be reflected that he has considered that behavior in light. I mean, it is, I think, still your burden to come forward with sufficient evidence to identify him as a level 2, right?
Correct.
Okay. By clear and convincing evidence.
Correct.
Okay. So where is it that you told us, or you tell me, because I got to tell you, I grew up, I was 13 once. People did this stuff, okay? And they didn't wind up as level 2 sex offenders as a result of it. Where is it that you explain to me as the judge who needs to be convinced by clear and convincing evidence, or more appropriately to the hearing examiner and to that is behavior that should be so considered?
First, I will say, there is nothing in the record before this hearing examiner. A hearing examiner must take into consideration the evidence before them.
Mm-hmm.
The evidence before this hearing examiner indicates that the person before them had an incident in their past as a juvenile, which he indicated was in school, it was against a classmate, and that years had passed. And you can know that he took that into consideration, Your Honor, when you look at the other accompanying behavior that took place with that incident, where he then called the female and indicated that he would stab her. The hearing examiner then doesn't even give full weight to that factor. So he does take into account the circumstances under which that incident took place. Maybe he did not say it in the best way, but when you look at the facts and how he applies the factors, he did take that into consideration, especially when you look at the accompanying conduct where they threatened that girl not to disclose or she would be stabbed.
So what tells us, I appreciate that, counsel, you're right. That is a defining difference. But where is it that tells us what the significance of that is at age 13?
There is nothing in the record other than what you have is the expert before you that does not even take it into consideration. So you're going to have to go on the evidence that you have before you, and the evidence that you have, Your Honor, there is nothing that says that that is normalized behavior for 13-year-olds in the record. So you have to just go with what you have, which is an incident of sexual misconduct that the person before the hearing examiner committed when they were a juvenile. Then you have that same person. Not only do you have the
beside the threat, there's nothing that tells us that it is or is not normalized behavior or behavior. There's nothing that tells us in the record the significance of that kind of behavior in considering it for purposes of 15 years later, whether that person should be determined to be a level 2 or a level 1 sex offender, right?
Well, I don't think you take that one fact that he was a juvenile when he committed that offense and plaster that over everything else that's applicable in this case, because that's what I'm trying to point out. Not only does he have that incident of sexual misconduct as a juvenile, you have the disturbing behaviors towards females before the sexual offense.
22.
Right. You have the restraining orders in between, his exhibition of violence towards women, 2 different women that he was dating in between. So this is someone, and the other factors that do apply. So this is someone, not only does he have that in his juvenile past, but you have someone that has exhibiting violence, someone who has exhibited that he is a danger, has made several women feel uncomfortable to the fact that he had a trespassing order from the school and he still came and continued this behavior. So I respect the fact that he has mental illness, but we have a person that had been escalating, and that's what the hearing examiner had before them. That's the picture of the person that was applicable at that time before the hearing examiner.
May I ask about the 16L letter, which cites a case that focuses on the need to show both repetitive and compulsive conduct under Factor 2, and Justice Mielke's concurrence in the case from last year. Is that argument properly before us, or has it been waived?
I think it has been waived since he hasn't been brought up. And on top of that, Your Honor, I think there is sufficient evidence in this case to show the impulsivity and the compulsivity of the individual before you.
And by that, I assume you're referring to not merely the fact that he exposed himself when he was 13, but also the repeated incidents of approaching women in libraries even before the index offense.
And the fact that they occurred in public places, because the fact that it occurs in a public place shows a lack of his control of himself, his impulse control.
Do you, in order for the board to show that conduct is compulsive as well as repetitive, does the board need to have expert evidence?
No, there is absolutely no case law that indicates that that expert evidence is required. What I would indicate to Your Honors is that the regulations have been properly promulgated. That was in 2016. They have the force of law, and the hearing examiners are mandated to follow those. And according to the definition of how Factor 2 applies, it would apply in this situation where you have someone that committed sexual misconduct prior and then subsequently commits a sexual offense.
Did Dr. Zeisel address whether this behavior was compulsive as distinct from repetitive?
I don't recall that specifically.
All right. Even if this issue has been waived, are you saying, even if we were to consider it notwithstanding a possible waiver, are you saying that the board would have, if it had been raised, the board would have found that this was compulsive behavior because of the public place and the repeated incidents in the libraries?
I think there's sufficient facts in the record to support the compulsivity of this individual.
I heard you say that, and maybe I misunderstood, but I heard you say that the way you understand the regulations, he had to find that this was repetitive and compulsive behavior under these facts.
If you look at the factor, Your Honor, factor 2 applies in a circumstance as this, as Mr. Doe's, where you have someone who committed sexual misconduct in the past, no matter the age, and then subsequently commits another act of sexual
if I read factor 2 in your regs, it's going to tell me that they must find repetitive and compulsive behavior under these circumstances without any further testimony?
As in an expert testimony?
Well, I'm just trying to understand what your position is because, you know, to me, it's counterintuitive. I don't claim to be an expert in this. I see a lot of these cases now, but it's counterintuitive that the behavior that we're talking about at age 13 and the behavior that we're talking about at age 22, leaving aside a whole lot of other things that you've correctly identified as relevant here, that shows repetitive and compulsive behavior. He's 9 years apart. They're not the same conduct. And he's 13 years old at the first one.
They're not the same conduct, but here's what you have. You have someone that not only did he commit this, he went to juvenile court for it. He was reprimanded by the court for it. He had more than sufficient time to reflect on the wrongfulness.
That could just be bad luck. I mean, you know, the fact that it went to court is, surely that can't be the determining factor that someone chose to make a case out of it. The determining factor has to be what were the facts, right?
When you look at the language of factor 2, it says the most weight shall be given to an offender who engages in sexual misconduct after having been charged with or convicted with a sex offense. Here, it's not a sex offense. It was sexual misconduct. It was sexual misconduct. It was a prior act of sexual misconduct. And you have someone that committed a prior act of sexual misconduct, went to court, was reprimanded by court. Years later, as an adult, maybe as a juvenile, he did not reflect on it.
I understand your point now. Thank you.
I'm saying as an adult, he can reflect on the wrongfulness of his conduct prior.
Right.
I just want to make sure I understand, and I have a follow-up question. So you are saying that the going to court is important because it gave him an opportunity to reflect on his conduct.
On his conduct then, because he had a period of supervision during that time. And then after that, as an adult, certainly having gone through that process before, here he is again in the court with regards to something with sexual misconduct, except that this time it's a sexual offense.
But I do want to just, and your time is up, I know I'm going over. We had some discussion when Attorney Burkholder was arguing about this issue about him getting medication. Was the only evidence before the hearing officer that these medical people were going to this man's apartment and giving him an injection?
From my recollection is, and you could look at the record, there was a community group that was supervising his compliance. I cannot recall whether or not that person gave the injection, but I know that there was a community group that was involved with the family that was helping him.
Well, so let's, I don't know, I'm going to have to look at the record on this particular point, but let's assume, I mean, what we have is this language in the hearing examiner's decision where he says, I do not find in the record any verification that medication is administered to him by a medical facility. And I'm not sure that's really the right, I'm not sure there's a standard here, but that doesn't seem to be, that I worry about that. If there is evidence that someone responsible organization is checking on him every single month and giving him an injection, would there be a basis for a hearing examiner to say, no, I'm not, no, that's not good enough for me?
What I would point out, Your Honor, that part of that language falls under pages 13 and 14 of the decision, which is in the addendum, it's 66 and 67. And that language comes under factor 33. And right after the hearing examiner writes that language, he gives mitigating factor to that factor.
Okay.
So that language is in a completely separate factor than not giving him any weight. He is given mitigating weight for that factor, even in light of it. What the hearing examiner is saying, he did not want to speculate as to the future compliance.
Counsel, is there any evidence in the record other than what was there from late 15, early 16, that he was not being provided with the required treatment, this shot every 3 months?
To the best of my recollection, that was something fairly recent. That was not something he had ongoing for quite a period of time. The shots was something that was recent that he began.
So the only evidence of that came from Zeisel then?
Zeisel or the petitioner when they put that into the evidence, to the best of my recollection.
Okay, thank you.
All right, thank you both. Well argued. I think that we, and I mean that, actually, I've said that a couple of times today, but it's been a good day. Really think that the arguments were great, and we understand everyone's positions. The matter is submitted. We'll take it under advisement. I want to also just thank our clerk and our whole staff through all the pandemic has really done a terrific job of making the court accessible both to the parties and to the public through these Zooms.